I am here, chat. I am here. So, we are live. You could be watching from anywhere around the country or the world, and I really appreciate every single one of you. Coming to you from the Spaceship Studios from a galaxy far, far away. And we are going to be talking about some trial updates. And also, we are going to be talking about the Gypsy Rose trial, some different things about it. As we have not done this in a little while. We've been covering OJ, and we will probably cover it more later. All right, and now we'll be switching over to the other window in a second. So those that may have been sitting here waiting, I appreciate the patience, and if not, that's fine too. We'll see you in a little bit. Okay, now switching over to the other screen. This is actually the wrong window. It's this window. Okay, there we go. That's also the wrong thing to click on. It's actually over here. And we're just going to close out this window right there. And there we go. Okay. All right. Let's put this window up here. In the Uvalde trial, it is still on jury watch, verdict watch. I'm getting a little bit off course there. It's not a. It's the other. It's not called a jury watch. It's a verdict watch. Okay. I'm going to give a general update about some of the other trials that have been playing, and then get into the other topics as well. Okay. All right. So one of the trials that we've been watching is the love trial, the love triangle murder trial. All right. And as of January 21, the murder trial for Brendan Banfield is currently underway in Fairfax County, Virginia. Banfield is accused of masterminding a plot to murder his wife, Christine, and Joseph Ryan to facilitate the relationship with the family's former upar, Juliana Perez. All right, the defense case begins on January 21, 26. The defense began calling witnesses after the prosecution rested its case. Motivations to dismiss denied. On January 20, 2026, the judge denied the defense motion to dismiss charges. The defense argued that M testimony was unreliable and DNA evidence did not implicate Banfield. Because a lot of times with the prosecution, I mean, the defense still do many things to try to show that their client is not guilty, etc. That's what they'll do a lot of times. As I said, this is not the Gypsy Rose one just yet. We're going to be getting there in a moment. Alright, so the Anastasia 9 dispute, the prosecutors claim that Banfield was fake profile Anastasia 9 on the fetish website to lure Ryan to his home after arranged rape that his analyst suggested Christine Banfield may have actually controlled the account herself. All right, so going over to the Gypsy Rose case that I was talking about, we're going all the way up here to explain it. All right, the case of Gypsy Rose Blanchard is widely publicized instance of okay, the microphone's on. I thought it wasn't working. All right, widely publicized instance of Munchausen syndrome by proxy that accumulated in the murder of her mother, Claudine D.D. Blanchard, in June 2015. Born 1991, Gypsy was healthy but spent her entire childhood being allegedly forced to. No, not allegedly, was actually forced to feign serious illnesses by her mother. Dee convinced doctors, neighbors, and charity that Gypsy suffered from multiple conditions, including leukemia, muscular dystrophy, and epilepsy and asthma. Forced interversions, Gypsy was confined to a wheelchair, fed through a tube, and forced to use oxygen tank, despite being able to walk and eat normally. Apparently, in surgical procedures, she underwent unnecessary surgeries to remove her salivary glands and had both of her teeth extracted. Isolation control. DD kept Gypsy isolated, shaved her head, and mimicked a chemotherapy patient, and lied about her age to make her appear younger and more dependent. Now, apparently, from what I hear, she seems very manipulative, my opinion, and of course was behind some horrid actions, and to this day has some bizarre videos that have surfaced that many others have been covering, and people are concerned that something else can happen again, but hopefully it doesn't. She says she has changed, but many are skeptical about that. Hello there, Aaron. Good evening to you. Welcome to the stream. And yes, completely. 100% nut bar. And because Mermaid and I have been talking about it, and she was behind the murder of her mother. Mermaid and I certainly think that she was definitely faking a lot of these things and has manipulative tendencies, and uses it all the time to, like a con artist. And she masquerades a certain way, but she really isn't the way that she claims to be, where she was really sick or something and she was faking it. And I think it's totally evil, irresponsible. Let's do this. Multitasking. And Aaron, I hope that you're having a good day and are doing well. Thank you for being here. Aaron said she makes you look good. Oh, bless you. Oh, thank you. Thank you. Yeah. She is good at making... Yeah, look good. Yeah, absolutely. The family received significant public support and charitable donations, including house from Habitat and Humanity, trips to Disney World. Looks like there's a verdict in the... probably going to be happening in Uvalade. We'll see how that goes, and I'll tell you all updates about how that happens. All right. And the murder discovery. As Gypsy grew older, she began to realize that she was not sick, as her mother claimed. She sought to escape, but as I said, she apparently has been faking these things and was being unjust with her mother. Right. Nicholas Go John in 2012. Gypsy met. Can I stream the verdict? Yes. In a way, I was kind of multitasking, in a sense. And yeah, I will see about that. Let's go here. Go to this other window. Let's see.
Really know, because the judge hasn't said that one way or the other, but he's given them this extra time, and apparently that's what they needed. They asked for some evidence to be brought into
right.
The jury.
They asked a couple questions. They wanted an easel. They wanted a list of the evidence. They wanted a list of the witnesses the order that they testified. They asked for a laptop, and they asked for a monitor. And then we also heard, let me go find the notes, that they had sent out some sort of clarifying question, some kind of question, but we never actually knew what that question was. And of course now we're just waiting to see what this jury's verdict is. And are you surprised that we're going to get a verdict tonight?
No, I'm really not. I suspected that it would be today, actually. I think that this is such a monumental decision for this jury that they did their due diligence.
Right.
Whether they had an opinion when they went into that jury deliberation room, they were going to go over every piece of evidence. They were going to reevaluate. They were going to go over the closing arguments and the statements, and they were going to see if the state had proved its case against Adrian Gonzalez. And I think it's commendable that they have taken this time, because they deliberated during lunch.
Right, they did.
Likely they've been eating dinner, so they have been dedicated to going through all the evidence to be conscientious. I think so. When they come back with their verdict, then it's an honor to whatever the verdict is. It's an honor to the guilty, or it's an honor to the not guilty. It is that they just didn't make a rash decision, go in and vote, raise their hand, come back out, and that was that. They really did listen to the evidence. I know a lot of it was emotional closing arguments today, but there were a lot of points that were made by the defense that, once again, I think raised an incredible amount of reasonable doubt. We'll see what the jury thinks.
Well, and I've said this a million times, you never know what a jury's going to do. I can't tell you how many cases I've sat there, I've watched, and I thought the jury's going to go this way. Oh, yeah. And then they go a different way.
100%.
Or they kind of split the baby. You never know. And I don't know really how you would do that in this case. But let me ask you this while we're waiting. What do you make of, what was your thoughts on the closing arguments that we heard today?
Well, I thought I thought that the closing arguments by the prosecutors basically was the equivalent of their presentation of this case.
Which was?
Kind of all over the place. And I thought that the defense honed in on some very important facts. For example, okay, here come the lawyers. For example, when they were talking about, when the prosecution said, we need to send a message. We need to send a message to officers that they've got to act, they've got to follow their duty, they've got to distract, they've got to deter, they've got to engage, whatever. And then the defense comes back and says, well, but the officers who had a line of sight, who did not take a shot.
What about all these other officers?
What about all of the rest of them? So what the message you're sending to the officers is just stay outside the courtroom, or out of the line of fire, or out of the scene, because then you have a better chance of not being prosecuted. I just don't know how that jury can think of those three officers with a line of sight to that shooter and hold them less responsible than Adrian Gonzalez.
Sorry.
Yeah, I know. Tanya's got, she's been doing this for 9 straight days, and credit due, you've done a fantastic job, but it's taken a toll. Yeah, and I'm not sure, it could be allergies.
Definitely allergies. And it's weird because it comes in and out. Like, okay, there it goes.
There it is.
And it's like a little bit like the little engine that could. When I get going, I'm okay. But again, okay, so we are seeing Nico LaHood, we're seeing Jason Goss, and we're seeing the other attorney in the courtroom. I don't yet see Adrian Gonzalez yet.
Right.
And we're just waiting. I mean, and this is the judge. From what we've been told, the judge has given everybody 15 minutes, time to gather in this courtroom, and you can. We're not seeing the images so much at the moment, but when we were looking at the faces of the families, obviously, they are very. This is hard. I mean, no matter where this comes down. This is hard.
100%.
This is a difficult thing. I can't even imagine sitting in that courtroom and, seeing those autopsy photos, seeing those images of those children wounded. That is, and we didn't see them out here, thank God, because of the way things were done. But that's got to going to change these jurors. But for the families, that's just got to be excruciating.
It is, and I think it's very difficult because it's so heinous. The whole situation is so heinous, and then America watched while 377 officers waited 77 minutes to breach that room. So it's horrific, and it's so huge. It's such a monumental a case, and this is a case of first impression in the state of Texas for the most part. But also, one of the things that you and I have talked about is that the state necessarily, I don't know if they necessarily focused on the actions completely of Adrian Gonzalez. They were trying this as they were introducing evidence that basically bringing in family members.
Do you think they should have done a more linear presentation? Because, I sat and watched this day after day after day, and I'm like, where are they going?
Right.
There was a couple days where we had just a tremendous amount of testimony from DPS investigators about ballistics, and it felt like that could have all been condensed into maybe one witness.
Right.
And, for me, what was effective was when we heard, and I'd have to go back into my notes, that there was something like 170 shots fired by the shooter, and the number of shots that were fired in room 111, and I'm trying to go back and look at my notes. It was a massive amount of firepower. But a lot of this stuff, I didn't understand, like, what story they were telling.
Well,
I struggled with that.
Well, exactly. I think that the fact that the shooter is dead, and they called him a monster. They were nobody said his name. I don't know if I heard his name one time in this trial, because they weren't going to do that. They weren't going to give the shooter any notoriety whatsoever. So they would call him the monster. They would call him the shooter. They would call him whatever. But the fact that he's dead, that's not enough. Right. If you know what I mean.
Right.
I think that if it had been enough, we wouldn't be here today. So it was almost as if someone had to be held accountable for this massacre.
Well, and I still think it is debatable. I've asked every expert who came on throughout the trial, would we be here if the shooter had lived?
My opinion is no. We would be trying a shooter for the deaths of 21 people. That's what we would be doing.
19.
Well, kids, but then we murder.
I'm sorry, you're right. 19 plus 2 teachers. You're right. I'm sorry.
And then we could have capital murder charges brought against them. Attempted capital murder.
Well, and then you would have, of course, the 10 children that got wounded.
Yeah.
I'm sorry, I got fixated on the number of kids that died because that's what it was charged in this trial.
Right.
Yeah, it's been strange to me. And then you have to wonder, what effect will this verdict have on Pete Arredondo, the former chief?
Right.
I mean, it's a different situation with him because he is the person throughout the majority of this incident that is calling the shots.
Right.
So
Right.
what effect do I'm curious what you think.
I think we're about to find out the effect that it's going to have on Peter Arredondo, Chief Arredondo, because I think if they come back with a not guilty, they may have to rethink it. They may go ahead and try him, but I think that they realize they will know. And by the way, the attorneys have the ability, if the judge, I know in Dallas, let me speak from Dallas, that oftentimes the attorneys can go in and speak to the jury before they leave. And I don't know if they'll do that in this case. I don't know. But it's sometimes helpful to understand what the jury's frame of mind was. And if the prosecution, whatever happens if they get a not guilty tonight, they may want to go in and talk to the jurors and find out what was lacking, what was missing.
Right.
And maybe then if they decide to go forward with the trial, then the trial's not set yet for Peter Arredondo. So, that's still up in the air, and I'm not exactly sure why. I think I've heard, but I can't remember exactly why.
I think there's some appeals going on related. I wouldn't claim to know all this, but there's some appeals related to him trying to get information about the Bortak team.
Okay.
That was the group of people
right.
that ultimately made entry. But it has something to do with that. And now again, his situation's different because he was the chief and he was the person calling the shots. He's the person who tells Gonzalez to go outside when the radio's not working to make the call for TAC. So there's a lot more, in my mind, culpability.
Right.
Because there's, command authority, he's the chief.
Right.
And when you've got those stars on your collar, you have more responsibility. But this is extraordinary because this is a rank and file officer being tried in the state of Texas under this statute, the first case we know of tried in this way. And, I have to wonder, though, of course we don't know, but could they have done a more linear job telling the story, the prosecutors?
Oh, yeah, without a doubt. Just, and trying a case is all about the story.
Right.
It is all about the story. Sure, there's dry testimony that you have to bring in certain cases, but again, I'm like you. Why the expert to talk about the ballistics in every cartridge that was found, or I don't understand that. I don't understand that. And so, yes, I think that it felt like the car was swerving all over the road.
Yeah, I couldn't. I mean, I felt like actually on day one, and I wonder if this is part of it, on day one, for folks that are joining us, we have been told that they have reached a verdict, that the jury has reached a verdict. They are waiting for everybody to gather in the room. You can see family members back there. I actually also see Rebecca Lopez there in the courtroom waiting for the verdict. We saw Adrian Gonzalez's attorneys had entered the courtroom. When we saw the shot up a minute ago, I didn't see him having entered the courtroom yet.
No.
But, this has been a hard-fought trial for everybody. I mean, this has been, no matter what happens, it doesn't change the tragedy of what happened here.
I think what we saw were some very incredibly brave witnesses. We saw people who were direct victims of this event, and they got on that stand and they testified, and you can actually see the physical damage to the teacher.
Oh yeah, the guy who had
111
his hand got shot in the hand. Oh my God!
You could see it, and oftentimes when we had a witness on the stand, unless it was a law enforcement officer, we didn't even see their faces.
Right.
The jury certainly saw all of that. They saw photos of the room where the children died, and 111, 112. They talked about. Just the devastation in that room. We didn't see that. If you're in that courtroom and you're sitting on that jury, you don't forget those images. And I think one thing the prosecution did here comes Adrian Gonzalez. One of the things the prosecution did do is he never wanted this not to be about the children.
Right.
So they emphasized, here we go, looks like something's going on.
Okay.
They may be bringing in the jury.
Please be seated in the courtroom. Members of the jury, I've received information that you have a verdict. Could I have the presiding juror stand momentarily? Is that verdict unanimous, sir?
Yes, sir.
As to each of the 29 counts?
Yes, sir.
Could you hand it to the bailiff for me, and you may be seated? Could I have defendant and counsel please rise? All right, your cause number 25 FC 0001U, the state of Texas versus Adrian Gonzalez. In each of the 29 counts, we, the jury, find the defendant, Adrian Gonzalez, not guilty. You see it? All right, members of the jury, I want to thank each and every one of you for your close attention and your patience and being with us timely throughout this trial. I know it was not easy for you. I know everybody was drafted, nobody volunteered. It was a long endeavor, and I want to thank each and every one of you for being here. I'm going to ask you one more time to go with the bailiff to the jury room, and we'll release you from back there. But thank each and every one of you, and would everyone rise for the jury to be excused. All right, Mr. Gonzalez, you were acquitted by the jury. Your lawyers can talk to you more about this, but you do have the opportunity within a timely manner to file for that expunction. They will tell you further about that, but it's incumbent on me to tell you that immediately after the verdict is returned. All right, we're in recess. Thank you very much. I'm going to tell them, folks, it's up to you. They're released from their instructions. I'm going to tell them that, and then I'll let them.
Okay. Okay, so there you have you have it. Not guilty.
Not guilty.
And so much emotion in that courtroom from the family, from Adrian Gonzalez. What's your reaction, Terry, to what we just heard?
Well, I think it's a correct verdict. I think there was ample reasonable doubt that Adrian Gonzalez endangered those children per the indictment.
They're released
So
from
what's
all their previous instructions, and I told them the lawyers may want to talk to them. It's a target.
Okay. Hold on.
Well, Emily, wonderful job.
Thank you. Thank you for the gift card. That was not necessary.
No, should have been more. I didn't realize it was going to be. But I guess, as I was telling them, the good news is, under Trump, the IRS doesn't tax overtime, so we don't get it. We don't get it, do we? That's what I'm trying to say.
But yes, that's
I don't know.
Bill, wonderful job. Thank you. Pleasure to meet you.
Well, we'll just continue to listen for now.
Living in San Antonio now? Where are you at?
Around Dripping Springs.
Oh, okay. I knew you weren't. I knew you weren't at Brazos anymore.
No. Thank you.
Bill, you value for the food, as we will, but maybe somebody not. It'll last till tomorrow. Somebody will take it.
Yeah.
Things
Seeing a lot of emotion in that courtroom.
Oh, yeah, right. Yeah, and I hear the judge talking to someone. What they'll do, Tanya, is they will release the jurors basically before they release others in the courtroom, most likely.
Open the door and say who wants it, and it'll be just fine.
Thank you. Wonderful job. Oh, they're great. Man.
Okay. Yeah.
Oh, it is? Okay.
So
good.
it looks like now Adrian's left the courtroom, and I see one of his attorneys still in there, and I hear the judge. Basically, I don't know if the judge is going to address the families in the courtroom. I don't know. I know Rebecca Lopez is there, and so she's going to have some insight on this. But
And then we are expecting press conferences after this.
okay, yeah, right. And the family, as you can see, they're seated there for a reason, and I'm not exactly sure what it is, unless the judge maybe is going to talk to them.
Congratulations.
You know, this has been exhausting for this family, for these families, and I think that may be part of what we're seeing too.
Right. With the grievance on the board.
I can't weigh in. I can speculate whether or not it's disappointment, but it's certainly heartache. It's certainly exhaustion.
Oh, I can't even imagine being these families.
Right.
There's something weird going on. And I continued to write them saying, like, hey, what's going on? Like, I updated with the By the way, just expect there's a few more things coming down the line.
Well,
Okay.
There's
Let's
supposed
go.
to have a.
Okay.
My recollection is the legislature put a time limit on it
Okay.
to dispose of cases.
I thought so.
Well, we can.
That's why I've been writing them.
We can.
I don't know if you have any suggestions. I'd like to hear them.
Okay, so Terry, what's your reaction here?
Okay. So we have a not guilty. I think the. I think the probably the most effective argument was, can you hold this man accountable and not hold 376 other officers accountable?
Right.
That he's the low man on the totem pole. He did act, and you can't look at it in a vacuum. You can't look at it, well, he did drive up once he heard there was a shooter at the school. And then, yes, he did run into the school, but it was that minute and a half or that period of time in between that he didn't do what he was supposed to do, is what the state was claiming. And the defense is saying, no, you've got to look at it in the totality of the circumstances. Basically, he did drive up into a situation. He did not know what was going on. He didn't know if he was driving up to the shooter, that if it had been the shooter, he could have hit him with his vehicle. I mean, basically that was implied. So it wasn't that he didn't do anything. He called in on the radio. There are so many different things that occurred with the dispatcher not being able to relay the information that they needed to relay, that the fact that the school doors didn't lock, they brought that into closing argument, that there are a lot of things that could have happened that might have also kept these children out of danger, that the officers that did run into that hallway, into the fatal funnel for the most part, if those doors had been locked, then maybe they could have encountered the shooter in the hallway. So I think the defense was trying to say it's not just the action of one officer that caused the injury or the who endangers these children. It was a variety of things. That one thing I think that I would have mentioned had I been the defense, and I believe I heard this correctly in testimony, is that the special ed teacher, she stopped the kids from coming out of the south wing, which is a fourth grade wing. She stopped them from coming out, and then she did say that she thought the shooter had gone in that south door. Well, that is the door that Adrian Gonzalez went in. He went into the south door. So as far as he may be thinking is that he was following that shooter right into the school, but he had to do a few things in the meantime to get some information, figure out what was going on. Okay.
What about Peter Redondo?
Yeah, you know, I think you're right. Tanya asked, what about Peter Arredondo, excuse me, the chief who has been held responsible and for being the chief who should have been in charge.
Right.
We heard testimony that the person that should have been in charge was the school resource officer chief, and he did not take command.
Right.
He didn't take charge. He didn't have his radios. He had left them in his car or at home or in the station or something. He did some things that you would expect a chief of a division to act in a different way. Now, Adrian Gonzalez, like you say, he was a low man on the totem pole, and those are not my words, those are Nico LaHood's words, that he was a low man on the totem pole, and he was doing what he thought his training taught him, and that he was following what his training was. He was trying to ascertain what the information was coming in, and he was trying to
All right, so the verdict in Uvalade is not guilty on all counts. A lot of people were wanting him to be seen as not guilty, and he was seen as not guilty. So, going here. All right. So there you are, chat, is that verdict. And if anything comes on else, we'll see. Whatever that is. Okay, and then Aaron says, oh, Gypsy, these fools meeting on a Christian dating site, they make us look bad. Exactly. And a lot of times Christianity, like other religions, get a bad rap, and when you have the actions of a few people, it's going to cause a stereotype to manifest itself. So when you have a manifestation of stereotypes, you have this murder that occurred, and these people doing these weird sexual things, and this is creepy stuff in the sense that it's border going in criminal territory, and then it's going to make like the Christian dating sites look bad, and it's going to make the Christian movement be tarnished in a way. So that's why we always have to be a good example, and there's many wolves in sheep's clothing that are going to try to corrupt and distort everything. Right. Okay, so going over this for, just an overview about it, is that like we were saying before, and we interrupted the program for the Uvalade verdict, and we showed it, and that was pretty cool. All right, and the family received. So this is about Gypsy Rose. The family received significant public support and charitable donations. And yeah, facts, Aaron. Family received significant public support and charitable donations, including a house from Habitat and Humanity, trips to Disney World. See, the manipulation she did was very effective in causing people to want to donate to her, give houses, because that's normal humanity. Because people want to help each other. Human beings are naturally like that, I think, and the compassion and empathy is important. Now, people like this, these snakes, are going to manipulate it for their own gain. And that's why we have to have the heart of doves, but have wisdom of snakes. So to know what the snakes are going to do, that doesn't mean we're not going to be fooled or duped. And the people that donated did nothing wrong, but the person behind it did, and they'll come in all kinds of shapes and sizes. And a lot of people will not know something until after the fact. But sometimes there's warning signs, of course. Other times there isn't. Now, the murder and discovery. As Gypsy grew older, she began to realize that she was not sick, as her mother claimed, which I do believe that it's shady what she's saying about her mother. Especially the murder was not something was valid, because she did do a lot of faking. And Nicholas Gojohn, which was the accomplice in the crime that Mermaid and I were talking about, in 2012, met Nicholas Gojohn on the Christian dating website, and they planned to murder over a period of roughly 1 year. Now, in Christianity, it says, "Thou shalt not kill," and we know a lot of times, there are, throughout history, there's been religious groups all over that have done things that are not good, that are going in Europe, going over in different Middle East, everywhere. There's different religious factions that have done things that were not right. Yes, that is true. That is correct. They met on the Christian dating site, and that's, as I said, good for the atheists, agnostics, and those that are not religious, and those that are against Christianity. They're not going to see it, Christianity, in a positive light, and that's why I always say we have to be aware of the stereotypes, because we're not like this at all, and this does not represent the Christian faith at all. But people might see this and get a little bit, what are these Christians really up to? Yeah, and as Christ said, there's many wolves in sheep's clothing. There you go. The killing. On June 2015, Gojohn traveled to Springfield, Missouri, while Gypsy hid in the bathroom. Gojohn stabbed Dee Dee to death in her sleep. So, this occurring was very gruesome and very bitter, and does not belong in a civilized society, because to go and do a murder like this in such a gruesome way is very evil and demonic, right? And core tenet of Christianity is to not kill. Now, you could do self-defense, if you need to defend yourself, but this was complete of wickedness. And doing it in the sleep where the person is not awake also. The school shooter, so the Sandy Hook shooters shot his mom before going to the school to do his dark deed. Yeah. So the sleep is like when someone is not around. Arrests. The pair fled to Wisconsin, where they were arrested after Gypsy posted a vulgar message to her mother's Facebook account to ensure the body would be found. You see, she's extremely nuts, going out and bragging about it, showing lack of empathy, remorse, and to just posting it up everywhere, and to just invoke horror into people. Oh, Moki. Yeah, that's probably a good idea. I agree. You can do what you want, but I agree. And oh, you're about money. Yeah, hilarious. Hit in the soft spot. Yeah. Oh, absolutely. I do agree, Aaron, that every day of she sees signs and being shown those things about him and that he's with her in spirit. Yeah, I do agree it's not necessary. Hello, Pussycat TV. Great to see you. We are talking now about the Gypsy Rose case. The Uvalade trial is not guilty. That is something else that happened. It's a not guilty. We've reviewed that a moment ago. We showed it. And now we are talking about the other topic about Gypsy Rose at the moment. And definitely a good point, chat. Okay. And the legal outcomes in sentencing. Now, this was... now, Gypsy Rose was eventually released. Now, many people are against this. And, yeah, there's speculation about her repeating it again, or just... and especially the depraved, sexual, perverted fantasies about daughter, it seems. Allegedly. And I think that was the person. It was something very horrid and perverted, and also about dead people, stuff like that. So these fantasies she has is extremely perverted and like something dangerous for society in general. So is it a shock value? Is she going to really change? We will wait and see, but it's something that people need to be aware of, that people can repeat offend. Of course, people deserve a second chance a lot of times, but sometimes they shouldn't. She's getting some stick right now. Yeah, on the latest Gypsy, yes. So, Gypsy Rose Blanchard pleaded guilty to second-degree murder in 2016 because the extreme abuse she suffered. Prosecutors offered a plea deal for a 10-year sentence. You see, the attorneys are very good at spinning a story or making it look a certain way. And they're good to have, especially if there's a problem. But a lot of times, if you have somebody that's bad that's released, it's not good. So, yeah, the attorneys did their job to get a 10-year sentence. Nicholas John, convicted of first-degree murder 2018, sentenced to life in prison without possibility of parole. All right, we got something here. Let's look what this is about. Going to diverge ourselves for a moment. Let's see. What's this?
But you never lose faith. You don't lose faith because these children that are no longer with us, that are at the cemetery, they can't speak for themselves. We speak for them. We fight to the end. And as hard as it is, they deserve it. The teachers, Irma, Eva, they had nothing on them except for valor, except for courage, and they fought to the end. They pushed back hard. They gave their life. The teachers, all the survivors, all the testimonies you hear, that you heard, all those poor little survivors that have to live with the nightmare. How do they look at themselves in the mirror tomorrow morning? They wake up and say, "Not guilty. The man let me down." You can't paint an image and portray him as some kind of hero.
Is this like reliving the pain that you went through?
Absolutely. Time and time again with the school district, with Uvalde PD, with the county. I mean, there's a lot of unanswered. Nolasco, where's Nolasco at? Where's that information? Absolutely nothing, right? Quiet, deflecting. Look that way, look this way, look that way. But don't look towards me.
Were you really hopeful for a guilty verdict?
I was very hopeful for a guilty verdict. I mean, at stake, what do we have? We have children at stake. Absolutely innocent children that did everything that they were trained to do. Hide, turn the lights off. But the officer that was trained to do exactly, to encounter, to go towards the shooter, to listen for the gunshot, everything, right? And what does he do? Sit back for an hour and change I'm sorry, for a minute and change, while the massacre continues to happen.
Do you think other officers need to be charged? There's only 2 so far. Do you still think more officers need to be charged?
Absolutely. You know, it sends a message that you know, and I'm sure there's some good ones out there that are going to check themselves in the mirror tonight and say, do I have the courage to do my job? And so, yeah, absolutely, the answer is yes. You got to look in every direction and say, you know, I'm going to hold them accountable. Because if you don't have it, just don't show up to work tomorrow.
What message do you have for Adrian Gonzalez?
Don't be fooled by your attorney. Your attorney can talk about sandwiches, a sandwich of coward, but there's something on the outside and the bread. It's insulting, to be honest with you.
Gypsy, ¿podría darnos unas palabras en español, por favor, sobre el resultado de este?
Decepcionado, totalmente decepcionado, y no es un dolor demasiado fuerte. Esperábamos una justicia, que lo hallaran culpable el Señor, y totalmente fue un respeto al jurado, pero es una injusticia.
Oh yeah, this is Nico LaHood. He is one of the primary defense attorneys for Adrian Gonzalez.
We didn't get a lot of time with them because then everyone couldn't leave until they left, but they were gracious enough to stay back. It was emotional for them, you can tell. They said there was gaps in the evidence. They appreciated us bringing out those gaps. They considered everything. They were very diligent. They worked very hard back there. They were very mindful and deliberate. We didn't ask them what the split was initially because there was not a lot of time for that. But obviously they were saddened because they know what the other families are mourning still. But they said there was a lot of gaps in the evidence and some of it didn't make sense to them.
What do you think this message sends to law enforcement? That was a key part of your case as well.
Well, I don't know if this case wasn't about us trying to send a message other than to consider all the evidence. I mean, we felt Adrian was innocent from the beginning when we analyzed the situation. We knew it was going to be a challenging case because of the emotions, the sheer emotions behind it, and those precious babies being taken from those families. And so we knew that. Well, I guess for us, as former prosecutors and defense attorneys, we would like to see more training with law enforcement in these situations that are so active and fluid and dangerous. And there's no one-size-fits-all for these situations, but also working with the schools. I think the schools need more funding. So that's a longer discussion, though.
Jason, why did you think the state decided not to call Salcedo and Mendoza? They were on the list, and did you consider actually bringing them in?
Yeah, I think we did consider it. As far as why they didn't call them, I think it was pretty clear that as the trial developed and we saw what they were trying to accuse Adrian of, we saw that there were actually other officers that were in better situations. And I mean, just as a former prosecutor like we were, I don't know that was going to help their case. And so by calling these other witnesses that had line of sight to the shooter, that had these other things that Adrian never had, it was just highlighting again, which we highlighted without them there. And so as far as your question about whether or not we thought about calling them, the fact that the state didn't said a lot to us, and we believe said a lot to the jury, and we were able to get out our point of view on that with their evidence and the lack of who they called. And so I think that's why. And to add to Nico's thing about training, this is the first time in Texas that an officer's training has been used as a mallet or as a cudgel against the officer. And one of the problems with the training, as we kind of saw from the evidence, is that it's confusing, is that it sends mixed messages. And its purpose was never to have somebody be prosecuted who went through a class because they weren't able to perfectly gather everything about a training or be able to apply that training in a situation that the training never contemplated. And so, I mean, I think that for law enforcement, I think that it is a wake-up call for them that they need to be aware that their training is being used by prosecutors to criminally prosecute police officers. And honestly, in this case, it wasn't right to do that to Adrian. It wasn't fair to do that to Adrian. Yeah. And it's not fair to do that to any officer because everybody out there was trying to do what they thought was right, and we know that there were failures. But it wasn't because they wanted to fail. It's because they were trying to do what they thought was right. And just going by a training and trying to use that as part of the indictment, that was count 2 of the indictment, is going to be, that would be a problem, I think, and it needs to be addressed. Whether that's, having officers, having the training people say specifically on the packet, this is not intended to be used as a criminal prosecution against any officer who goes through this training. So that was a big thing that we saw throughout. And I think also to talk about what Nico said, we wanted these facts to come out because as the facts come out and we see what Adrian actually was doing and what he was putting his life at risk to try to help those children. He was. That's what the proof, the prosecution didn't dispute that. The proof that everybody saw and everybody was able to see showed that Adrian was willing to risk his life and did. Yeah. And that we were glad that the jury saw that. We were glad that that came out.
And that wasn't part of the narrative this whole time, and so that was challenging because everybody heard about this case. During jury selection, this whole room had 450 people in it, and everybody raised their hand that they had heard about this case. Now, the extent of what they heard and whether they made up their mind, of course, we're doing that questioning back and forth. We had a questionnaire as well, and so that was a challenging part of this case as well because there was a narrative out there, and frankly, with all due respect, there was a false narrative out there, and so the true monster in this situation was lost, and then it was all directed at Adrian, and so that was an uphill battle from day one in this case.
During voir dire, there was some auditory outbursts. Have you ever had a voir dire hearing where you could, people have views? I mean, what are your sense on that?
Well, I don't think anybody's had a voir dire this way, but it was new for us as well, and we've tried a lot of cases together as prosecutors and defense attorneys, and it was unique. I mean, just the sheer size of the veneer panel was unique. And so, that was unique and that was different, but we had to deal with it. We had a plan dealing with it from day one. We had a strategy going into voir dire, to opening statements, to the way we were going to present evidence, and how we felt that we were going to use the government's witnesses to bring out points, and then wrap it up in closing. And then what we decided at the last minute to not call witnesses because you're always trying to figure out where you're at with a jury based off how the evidence is going from the government. So those are game time decisions that we had to make.
Nico, can you just talk about your strategy here? I was very intrigued because I think I've been wondering if you thought maybe at some point you went too hard or you were over defending. Maybe that's not the best word. But
no, you can ask it that way. Yeah, and I asked the jury that specifically, and they said no. They thought it was appropriate. You're talking about Ranger Hill?
Yeah, or just even in your closing, right? In your closing argument, you were kind of almost apologizing.
To whom?
To the jury or something, if I went too hard.
Well, I was referencing Ranger Hill.
Okay.
I mean, because you never know, and obviously I didn't take that tone with every witness. The jury said that it was appropriate based off, and that's how I felt it was, and that's why I did it. And because so yeah, I did. I think about that often. We all do when we're cross-examining witnesses. Obviously, we don't start out that way, but we have to respond appropriately based off the witness, and we prepare them in voir dire, by the way.
Is there anything else you could share with us about what the jury told you about?
Just about the gaps. They talked about gaps. They talked about perspective, what the government didn't prove on Adrian, and then they saw what he did do, and based off with officers, they were very attentive, and they listened, obviously, very directly, and it seemed like they were catching our theme develop as the trial went on. We didn't have a lot of time with it. We let the government speak first. Christina wanted to talk to them and really get into it, and I knew that it was very personal to her because of the community. So we kind of yielded our time to her with them, and then the judge called us out.
I have a question, if you don't mind. How does Mr. Gonzalez feel with this verdict? How does this...
Is there anything you can say? Can we hear from him if possible?
First things first, I want to start by thanking God for this. My family, my wife, and these guys right here. He put them in my path, and I'm just thankful for that. And thank you for the jury for considering all the evidence and making that verdict.
Is there anything you want to say to the families?
No, not right now.
Would you like to say anything about what this entire ordeal has been like for you?
As lawyers?
Well,
for Ms. Gonzalez.
Talking to Adrian right now, obviously it's very emotional. So, but I can tell you, I think any one of you can imagine that everybody who's been here, sorry, get me in the mic, that everybody who's sitting in front of us right now, I mean, y'all can't see, I mean, the people that are watching, you can't see it, but I can see just a wall of people in front of me, and that wall of people has been reporting on Uvalde, and not necessarily unfairly, but it has been reporting ever since Adrian was charged that he failed to do his duty, because that's what the prosecutors charged, and that he failed in some way to try to do everything he could to help these children. And the evidence showed that that wasn't true. And the evidence showed that not only did he not fail, but he put himself in great danger. So you can imagine how somebody who has had the entire country look at him as somebody who who was not willing to do his duty, and he is a proud man who does do his duty, and he went in there when it was time for him to go. He went in there, and he was one of the first 5 in, and going down a hall where a rifleman, a gunman with a rifle, could have easily ended his life, could have easily made his wife a widow, and he was willing to do it because he did want to protect those children. So he went through all of that, and so the feeling that he's communicated, and that he'll be able to communicate, I think, in the future, is that it was obviously extremely difficult. It was difficult for the community, difficult for his family, difficult for him.
Iko and Adrian, you guys shared a pretty powerful hug right after that verdict. Just walk me through the emotions in that moment.
I mean, it's overwhelming for him. For us as well, we take on the burdens of our clients. We take it very personally. For me, I believe it's about stewardship. When a client comes to us as a firm and says, "I trust you with my life," I mean, it's not. I take that very serious. I don't sleep. I'm a prayerful man. I pray for wisdom in how to handle and how to conduct ourselves in trial and to think. And for us, we got to make sure that nobody's going to outwork us. And so, for us, it was kind of a culmination of his trust in us and our hard work together. And we didn't do it alone. These 2 lawyers are amazing. I learn from them every day. But then we have Michelle and Joseph as well, and then the team back at the office. So it was bittersweet, bitter because we know that there's people that are sad over this verdict. And as someone who's gone through the loss of my brother, who was murdered in my driveway, and I know what it did to my parents, and so I felt for the family. I thought of the family. I was hugging him, for us, and for the family members, to be honest with you.
Mr. LaHood, you've been a DA. You've been on the other side. You also brought up Randy Hill. Do you think and can others be charged in this?
Well, I'm not going to make a charging decision for Christina. She's the elected DA. She has to answer to her voters. But
I get that.
and make that, yeah.
I mean, you brought him up to the jury in closing. Do you think there's other people that share culpability?
I'll reserve my judgment on that, on my comment on that.
So why do you think they haven't charged anybody else? I mean, it went from DPS all the way down, and they ended up with Adrian and Pete Arredondo.
I'm not going to speak for Chief Arredondo. I think for Adrian, it's what we said in closing. He was the lowest man on the totem pole, and I think they thought he was easier pickings. I mean, I'm not speaking to Christina's intention. I mean, I'm not saying it was, with immoral or anything like that or unethical. But I mean, I just thought they probably thought he was the easiest one to charge, in my opinion.
I want to ask you, very few of us have seen everything in this. You've had access to everything. Is there something that the country can learn, law enforcement can learn from this, based on your experience, based on what you see here? Because this is going to happen again, sadly, in this country.
Well, there's a lot. I mean, this is a synergistic effect. When I said in closing that if that school door would have been locked, if those classroom doors would have been locked, if they had cameras on the outside of the schools, if we had officers that, to Jason's point, had clarity in their training and then had the resources of what to do, if there was officers assigned to schools with the right equipment, with a long rifle, with handguns. I know it looks bad for people, but this looks even worse, and it feels worse for those precious families. I mean, so what is it going to cost us to protect our treasure, which is our children? We should say there's no cost. Money should be no object. And so if you want to make difference, you have to bring everyone together, training in shoot houses, meaning actively train in realistic scenarios so these officers will, as they say, fight like they train. You have to train. You can't just do PowerPoints and think that someone has information that's going to sink in. This is muscle memory as it came up during trial. So this is a longer conversation that I'm happy to have because we've seen situations like this before. But it's a synergistic effect of many of the things that I just mentioned.
Adrian, what does moving on look like to you?
Just picking up the pieces and moving forward. That's it.
Adrian, do you speak Spanish? Como nada más para ver how do you feel in Spanish?
No, it's,
The prosecution made it clear that they wanted this case to be a message for other law enforcement officers to find themselves in a similar position in the future. Do you believe that this case could be used as precedent for other cases?
I hope not. I hope other prosecutors don't see this case and think that they can go forward with these specific facts, with the law that they used as a case of first impression, with the training that the officers did or didn't have, with the resources that were not provided for them, with the school district that unfortunately did not provide the best situation for those children. I hope this is not the example moving forward, and I don't think it will be, but I can't make that decision for them.
Mr. Hood, the families are distraught, in tears. Your message to them?
I'll continue to pray for them. I mean, I can't to say that I understand. I've experienced that with my own family and with my brother's passing, but I mean, it's a genuine hurt for them. It was bittersweet. There's no winners in this situation because they're still mourning, and I understand that. Thank you, guys.
Thank you.
Okay, Tanya, yeah, we heard that the defense team did speak to the jury. The jury explained some of the reasons they came to the decision that they came to. One of them is that there were gaps in the state's evidence that, again, if you use your common sense, they can't overlook the gaps.
Right.
That they just didn't feel like the state proved its case. And I say this with a lot of compassion for the family, but the criminal justice system worked tonight.
Right.
It worked this entire trial. It worked. The state has the burden of proof. They have to prove every element of the indictment. Those are the elements that they've charged him with, and they have to prove each one of those. And the defense does not have to present a case. They can cross-examine, and that's what they did. And it looked to me like what they were doing is they were turning the state's witnesses into defense witnesses. And I know you agree, right?
Oh, yes, absolutely. Oh, yes, we're going to go listen to the families.
I mean, I'm no future teller. I can't tell what's going to happen. But we've got to get it right. If not for us, if not for our kids, I just want people to start acting for their own.
Why is your presence here at the courthouse important?
Because I made a promise to my son that I would never stop fighting, and you know, this country, the state already made a liar out of me once when I swore to him that I would never let anything bad happen to him. They made a liar out of me. The city, the school, the state, the gun industry, they all made liars out of me. Nothing will make a liar out of me when it comes to fighting for my son.
Brett, we appreciate it. Thank you so much.
Yes, ma'am.
About
okay,
so talk to us about just kind of reacting. You know, Jason Goss was talking about how saying that basically the officer's training was being used against him. Talk about that.
Yeah, right. What they were said is this is the first trial where an officer's training came in to indict them, basically
on an active shooter,
on an active shooter, because he said, as he said, if they aren't perfect and didn't follow the training. And by the way, what they did point out in the trial is that there is not all trainers train the same way, and not all trainers have the same idea of what active shooting looks like. It is not like a mandate from the state that this is how you conduct active shooting training. And the witness that they brought in, he didn't even they didn't even ask him if he thought, the state did not even ask the trainer whether or not Adrian Gonzalez failed at his duty. They didn't even ask him that. And so, but he did admit that this is one curriculum and there are other curriculums for training. But Jason Goss's point is that this is the first time that an officer's training was used against them, and the fact that he wasn't perfect. He again, what you have to look at the totality of the circumstances. You have to understand that none of these officers thought this was a bailout. They just thought it was maybe a standard bailout. I think they had 40 bailouts from March to May. And so that's what they thought it was, somebody running through the school. They didn't know. So the minute and a half that the state was indicting basically Adrian Gonzalez for is you're eliminating and you're taking out of the equation what a human being, an officer, has been trained and what he would normally do in this type of situation. And again, I think what really hurt the state is that they conceded the fact that Adrian Gonzalez never laid eyes on the shooter. He did not know where he was. He was trying to ascertain information, and he was trying to communicate that information to other officers. He was calling for backup. He was doing something. But what I thought was I think Nico LaHood is relatable. And I think out of all the attorneys, he was very relatable, as he even mentioned that his own brother was murdered in his driveway, and he knew the pain that caused his family, and knows the pain that this jury was going through. I mean, not the jury, the families are going through. So he came across, you bring yourself into the trial. You don't leave yourself at home. You bring your experiences, you bring who you are into a trial. And I really think Nico LaHood was relatable. Right. And I think he related to the jury. The jury probably related to him. He kept emphasizing that he didn't want to be disrespectful, but I have to ask the tough questions. I think that he just did a very good job of staying on track. And that's one thing he said, is he thought that the jury just realized what direction they were going, what their message was, constantly kept hammering the same message. And I think that's what got lost with the state, is that you weren't exactly sure what their message was, right, where they were going. You weren't sure. They would bring in a ballistics expert, and then on the maybe, and this isn't exactly it, but this is basically the order in which they call their witnesses. They might have a ballistics expert, and then they might call in a doctor who worked in the emergency room, and then they might bring in a Texas Ranger to testify what Adrian Gonzalez said, and then they might bring in a family member whose child was injured and in the hospital. So it felt disjointed. Okay.
What did you think about what Adrian Gonzalez had?
Yeah, I thought that was interesting. Adrian spoke for just a moment, and he thanked the jury. He thanked them, I'm sure, for not just gratuitously, thank you, I'm not going to have to go to state jail, prison now, or whatever, I'm not guilty. But he thanked the jury, but I believe the question was back to him, do you have anything to say to the family? And he said, no, I don't.
What do you think about that?
I think that maybe that was an opportunity for him to, if nothing else, Nico LaHood said, who's the defense attorney again, who said, I continue to pray for them. But if Adrian Gonzalez had just said, I'm praying for them, then maybe that would have been more appropriate than, no, I don't have anything to say. And as you notice, his defense attorney, Jason Goss, stepped in then and said, this is an emotional time. We're going to let Adrian process this. This is just we're just, in other words, we're not going to let him say anything else for the most part, right, without saying that. But yes, I think that would have been an opportunity for him to say, I'm praying for this family. I'm praying for the families.
Yeah. What do you think about what we heard from the families, though?
Yeah, I asked Rebecca. I wondered, after the families who were in the courtroom and listened to all the testimony, did they have any kind of maybe compassion for Adrian Gonzalez? Did they feel like maybe he was scapegoated? Did they feel like other officers should be indicted? And she said no, they have never expressed that, and that's what we heard with the father, who said, this again is just a slap in the face, is that we've lost these children, and everybody let us down. The officers let us down, the schools let us down, on and on and on. There were a lot of people, a lot of entities that he feels that let them down, and nobody's had to pay for it.
Okay, so let's go take a listen to Adrian Gonzalez.
First things first, I want to start by thanking God for this, my family, my wife, and these guys are here. he put them in my path, you know, and I'm just thankful for that. And thank you for the jury for considering all the evidence and making that verdict.
Is there anything you want to say to the families?
No, not right now.
Would you like
Okay, so Terry.
Yeah.
Go ahead.
Again, he's thanking his defense team. He's thanking the jury. He's grateful. Of course he is. He's got to be relieved. And you know, it goes without saying that he's been traumatized as well. I mean, the whole experience was traumatizing for him as well. It doesn't excuse the 77 minutes before they breached that classroom. I think that's what most people think for sure. And we're going to go listen to the verdict again. If you didn't hear it, this is a not guilty, and we're going to go listen to the verdict from the trial.
The state of Texas versus Adrian Gonzalez. In each of the 29 counts, we, the jury, find the defendant, Adrian Gonzalez, not guilty. You see it? All right, members of the jury, I want to thank each and every one of you for your close attention and your patience and being with us timely throughout this trial. I know it was not easy for you. I know everybody was drafted, nobody volunteered. It was a long endeavor. And I want to thank each and every one of you for being here. I'm going to ask you one more time to go with the bailiff to the jury room, and we'll release you from back there. But thank each and every one of you, and would everyone rise for the jury to be excused. All right, Mr. Gonzalez.
What's your reaction?
Yeah, well, the reaction is that I think those 12 jurors did an outstanding job. And not just because they came back with a verdict that I think was the right verdict. They came back with a verdict because they thought it was the right verdict. They spent all afternoon. I think they broke after closing arguments around lunchtime. They deliberated through lunch. They spent all day deliberating. They did not make a hasty decision one way or the other. They looked at the evidence. I know I was texting you at 5:30 thinking that the judge was going to release them at 5:30, and you said no. The judge said they're going to go until 10 o'clock if they need to tonight. And so the jury sent out some questions for the judge, and that's the only way they can communicate, by the way, with the judge, is they've got to send out notes to the judge, and then the judge can respond. And usually, certainly, if they are asking for pieces of evidence, the judge is going to send back that evidence. And you mentioned they asked for a laptop, an easel.
They wanted a list of the evidence. They wanted the order of witnesses. They wanted a monitor. And then they had some other question. Rebecca mentioned what it was, and
yeah,
they had something about Melody Flores, I think.
Right. Yeah, they wanted to know more about her testimony, I think, too. So they did their due diligence. I don't know, and I couldn't hear Nico LaHood, again, the defense attorney, at first when he started talking about his conversation with the jury. I don't know if they were unanimous all along. I don't know if they took a vote and some were split, if it was a split vote. I don't know, and I think I'm going to try to find that out. But I'm curious about that. Oftentimes, the first vote is a split vote, and then as they talk more about the evidence and the case and what they heard, and it is a discussion, then oftentimes people will change their mind. I mean, you can see any television show about jury deliberation and know that. But that I'm not exactly sure what he said about whether or not the jury was split for a while.
Right. Hey, Pete. Pete's the producer back there. What's the chances you could pull up Nico LaHood's what he said? I mean, can you you don't have that ready? Okay. If this is not done on a dime, they have to clip it and put it in the system so we could actually re-listen to it. You know, as I watched this trial throughout, I just kept thinking, why this guy? Like, why this guy out of all the police officers? And it kind of came down to, well, he's the first one there by like 45 seconds. And then I'm going, well, wait a minute. He does do things. Maybe you don't like what he did. He drives up on to the school grounds. He goes to Melody Flores. He's trying to ascertain what's happening. You know, maybe he should have gone into school faster. I don't know. I wasn't in that situation. And it felt like we were doing an extreme case of Monday morning quarterbacking.
Right.
And then when you find out and you understand that there are officers on the other side that have line of sight of the shooter and that one of them has a rifle, and you just go, wait a minute. Well, okay, I'm trying to understand. And, what happened there was horrific and tragic and terrible. But Adrian Gonzalez is not responsible for that entire 77 minutes.
No, and if he didn't do his duty and follow his training, then what about the other three officers? What about the other officers that came on the scene and were standing around and didn't even go into the school? I mean, the list goes on and on and on. So that's why people were like, what is it? Why this guy? And as the defense attorney said, he was a low man on the totem pole. Maybe he was easy picking, because it really didn't make any sense, because he didn't just huddle behind his car hiding from a potential shooter. He did take action. So I think that what he was held accountable for is that when he heard the shooting, because that's in the indictment, when he heard the shooting, that he didn't just say, I'm going, I don't know what I'm going to, I don't know what I'm going to be facing, but it was almost as if the thought was, it didn't matter if you were going to be mowed down by by a killer who was going to kill anyone in his path.
But he doesn't. He doesn't know it. Sorry, guys, I'm trying to get my voice. There he goes. He doesn't know what he's confronting at that
Exactly.
moment.
But they expect him to go anyway. That doesn't make sense. It doesn't make sense. And as I pointed out, even with the officers' training, that's not what they're trained to do. They're not trained to go into a situation that they don't know what's going on. They try to gather as much information as they can. And they were talking about the gunshots. They weren't exactly sure where the gunshots were even coming from because of the echo off the building. So it was a completely confusing situation. And that's why it's hard, everything in retrospect looks a little bit different than if you're right in the middle of a chaotic, very horrible, terrifying situation. Everything is a little bit different. And, officers aren't robots, and they are not superheroes. They are human beings. And so, yes, they need more training. And that is one thing that the defense attorney said, that a reporter asked him, so what do we learn from this? What should we take away from this? And what he said is that we need more training for officers, obviously, and maybe a more consistent training, and also that more resources for the schools. Because one of the things that came out in testimony is that these doors didn't lock, or they had goofy locks on those doors because they didn't have the money to change them out.
Right.
I mean, you look at that and go, that is crazy. They couldn't lock, and they used magnets to keep the doors open, because if they locked, it was up and down, and they had to let a student in who had gone to the bathroom. So they even issued these magnets to keep these doors from locking. So if they had the proper, maybe the proper locks, if they had the funding, if they had support, then maybe the story would have been different. But as a parent, I don't want you to learn all this stuff when my child is sacrificed. I don't want my child to be the sacrificial lamb for your training or your funding. I mean, that is why I'm sure they're so appalled. It's just like, even if Adrian Gonzalez is the low-hanging fruit, he's fruit. Right. And we want somebody to pay. We want someone to be held accountable, and the monster cannot be held accountable in a court of law. And as Nico LaHood said, the officers breached that door, finally went in there and sent that son of a bitch to hell. I mean, it was, he was going to kill anyone he came in contact with. So those officers did the best they could at the time. I don't know if that's the case for 77 minutes. They didn't have the equipment. They're waiting for certain equipments to breach that door. It just seems ridiculous that there are 377 officers out there and they could not have acted faster. Nobody understands that. Tanya asks, would we be here? Would Adrian Gonzalez be indicted for endangering children if the shooter were alive? And my answer to that is no. I don't think so. They would be trying a shooter for capital murder, attempted capital murder, because you murder those children, and that's capital murder. And he would be tried for attempted capital murder. I think that the person who was responsible for this would be tried, and I don't know if the officers would be, because if you think about it, if they had gone in and captured him, there still would have been 77 minutes, right? There still would have been 77 minutes while that these officers were waiting to go in. So if they were able to capture this monster, as they kept referring to him, if they were able to capture him somehow and he was alive, and then they could try him, there were still children who bled to death. There was a teacher who bled to death because they didn't get in there fast enough. So where do prosecutors go from here? I think that they reevaluate their case. I think they grieve. I think they will grieve. I think this is, I think that they probably will look at the Chief Arredondo's case, and I do think that they'll try him, and I think that their case will be, they learned a lot from this experience. I think they learned a lot from Adrian's case. I think they're going to be probably more strategic in how they present the evidence in this case. And by the way, they also know where their weaknesses are. They know where those witnesses are that can actually hurt them once they take the stand. And again, it's the indictment of one officer when there are so many who didn't act. But he was in charge. He was the chief of the school resource officers, the six member school resource officers, but he was the chief. He got there first, and he should have taken charge, but he didn't. So they may try him.
You think we would?
Yeah, I do think it'll be a different trial. I definitely think it'll be a different trial. I think both the defense, whoever Arredondo's defense team is, they learned a lot from this trial. And I think the prosecutors learned quite a bit from this trial. I do think it'll be different. I think they will be able to say, we can hold him responsible. We can hold Chief Arredondo responsible. He was the point man. He didn't follow his training because he didn't set up a command situation. He didn't do this, he didn't do that. But so I do think that they will have a different argument when it comes to the chief, without a doubt. All right, okay, so we have had a dramatic last 9 days. We ended up with a trial, a not guilty verdict. The jury did its job, and we will learn a lot from this. And we'll be here continuing to talk about this. And thank you for having me. I really do appreciate it. It's heartbreaking. It's heartbreaking, the outcome, what happened to these children. But I think this was a win for justice.
Thank you, Terry.
You're welcome.
I'm sorry for my voice.
That's okay. Thank you for having me.
And so we're going to wrap it, folks. And we'll be back when we have the next trial.
Yeah.
Thanks for being with us.
All right, that is it for them. Now we're going to go back to Gypsy Rose. Okay. All right, so that was the Uvalade coverage. So he was found not guilty. All right, and now we'll continue with this part.
Scared.
All right, so continue. We're talking before about Gypsy Rose, and we're going to go to this right here, and I'll read the list while we talk about this. Hello, Fifi. Good to see you. Welcome to the stream. We saw the verdict, other child not guilty, and right now I'm talking about Gypsy Rose Blanchard at the moment, along with some other trials that we were talking about today. Hope you're doing well. Nice to have you here. And the case shocked the public when it was revealed that Gypsy could walk and was physically healthy. You see, this was the part where she was faking a lot of the symptoms that she was claiming to have, where it really wasn't what she was claiming it was. You're trying to faking an illness but not really having it. Right. Gypsy Rose Blanchard pleaded guilty to second-degree murder in 2016 because of the extreme abuse she suffered. Prosecutors offered the plea deal a 10-year sentence. So with her attorneys and the prosecutors, the abuse that she was experiencing, they were saying she had, this caused them to give her a plea deal. All right. Now, Nicholas Gojohn, convicted of first-degree murder in 2018 and sentenced to life in prison without possibility of parole, which a lot of people think she should have went to prison for life also because she could have repeated the offense, but she was released after 10 years. After serving 85% of her sentence, Gypsy was released in parole in December 28, 2023. And she's become a major public figure featuring in multiple doc series, The Prison Confessions of Gypsy Rose, and the reality show Gypsy Rose Life After Lockup. And as of 2020, this is like some more updates about it in the current time period. Now, she has come out with some disturbing videos and that have been reacted to by people on YouTube, where she's showing signs of disturbing nature mentally. But the overall updates are Gypsy has been fully transitioned until she's mother and public figure, having recently completed parole, and she has a new daughter in year 24 named Aurora Reina. In a living situation in June 2025, after officially completing her parole, Gypsy moved in with Ken Yerker. Previously, parole restrictions require her to live with her father and stepmother in Louisiana. Future plan: Gypsy has expressed interest in expanding her family through to avoid passing on her genetic condition, micro deletion 1q21.1, which Aurora did not inherit. Now, certainly people like her, in my opinion, want to have lots of attention and, be in the media. But of course, it's a case that is well known, so obviously she's going to be on featured in shows, etc. And the television projects, her reality series Gypsy Rose Life After Lockup was renewed for the second season, which premiered March 10, 2025. Season documents her divorce from Ryan Anderson, her rekindled romance with Ken, and her journey through pregnancy and new motherhood. Advocacy. Gypsy continues to platform to raise awareness about Munchausen syndrome by proxy, which, as I said, I think a lot of this could be, she's a lot of deception to her, and mental health, stating her mission is to make her experiences worth something. Emotional healing, physical transformations, weight loss, and it appears that she is trying to do better. Now, the controversy surrounding Gypsy Rose centers of complex debate over whether she is a victim who should be celebrated or a calculated participant in a murder who should face greater accountability. This divide has testified following her 2023 release from prison. Alright, so there's victim versus calculated murder. Now, as I've said before, she seems to express signs of manipulation. And also, some people think she really was a victim. Then you have the victim perspective. Supporters argue that Gypsy was pushed to extreme measures after decades of severe medical and physical abuse. They say they see her as a survivor of Munchausen syndrome by proxy, a fictitious disorder imposed on another whose only escape was through action she took, some people say. And then, shout out to Mary Toodles. The calculated narrative. Opponents point to evidence of premeditation, noting that Gypsy spent over a year planning the murder with Nicholas Gojan and had several plans to be with him. Critics often contrast her early release with Gojan's life sentence, arguing that her role in orchestrating the crime was just as severe as his role in executing it. Yeah, and as I said, that's an ongoing debate about it, which I think she was being deceptive, and she did plan out the murder. The celebrity status. Gypsy's swift transition from immediate to reality TV star and social media influencer has drawn significant criticism, monetizing the trauma. Many find problematic that she has capitalized on her mother's death, though multiple documentaries like Gypsy Rose's Life After Lockup and a 2024 memoir, critics argue this glamorizes murder and prioritizes fame over genuine healing. Social media behavior. Public opinion soared in 2024-25 due to her online feuds and perceived erratic behavior on social media. This includes deleting and reactivating accounts, turning off comments to avoid criticism, and allegedly engaging in doxing critics. Also, all that is a bit unnecessary, considering the circumstances, where it would actually make her look more of a calculating perpetrator. Let's see. Pussycat says, but Dee Dee capitalized on her daughter's lifelong torture. And Pussycat, explain to me exactly how she did that. I'm curious. Thank you for mentioning that. Okay. Personal life and relationship drama. The timing, nature of their romantic relationships since her release have sparked widespread public scrutiny. Divorce from Ryan Anderson. Within months of her release, Gypsy announced that her separation from Ryan Anderson, whom she married while in prison. Reuniting with Ken Yerker. The controversy peaked when she rekindled her romance with ex-fiancé Yerker immediately after her split from Ryan in 2025. She was criticized for wearing a wifey shirt while her divorce from Ryan was still pending, and she was already pregnant with Ken's child. Now, disturbing viral clips. Now, disturbing viral clips in January 2026 footage surfaced showing Gypsy's role playing as evil persona named Demona, and these clips recorded before 2015 said she reportedly described graphic violent fantasies. And even if she was abused, or if there's truth to what you're saying, what she did was not right with the murder part. And I do think on her own, I'm not denying that could be the case, as I am just learning it. I'm just learning about it. I think she, on her own, would have done these things anyway, even if it wasn't for that factor. But it still doesn't mean it was the right thing to do by murdering her mother. And I don't completely trust her. I do think she was good at acting a certain way that she really wasn't. And she has come out with certain viral videos of her strange fantasies that are very perverted and dangerous, I'd say. And people are concerned that maybe she could repeat something again. And even if, as I said, you're completely right, she was not maybe in the best mental state to be out and about on the streets, in my opinion. But hopefully she doesn't repeat it again, and she can live a normal life. But yeah, there just seems to be some fishy things that are occurring that people are not completely convinced that she's 100% there. Alright, and let's see some other parts of this. And over 100 previously released videos were made public through Freedom of Information Act. This is where most of the controversy is at the moment. The Freedom of Information Act, FOIA, request primarily surfacing via the Into the Weeds podcast. These clips recorded Gypsy Rose Blanchard between 2013 and 2015, featuring the evil alter ego she named Demona. Let's see. Gypsy created this persona as part of the shared fantasy with Nicholas Gojan. Donaldson submission, the video Gypsy Demona refers to Gojan as slave, demands he pleases her, the vampire fantasy. Which people could have their own fantasies, whatever with their personal lives, but the point with her is that with the murder and stuff, there seems to be some question about that it's going to go from a people doing stuff in private to something else that could be not too good. But of course, all this is speculation and just for people discussing this case and being aware of what could be, what cannot be. The vampire fantasy. Scared. Much of their roleplay revolves around Gojan being the vampire and Gypsy acting as a dark, powerful figure who oversaw his actions. Now, the most disturbing content Controversial clips involve graphic and criminal fantasies that have led to many question Gypsy's past claims of being forced into murder plot by Go John. You know, that the overall that she could be a mastermind behind it. Alright, the future children. In widely shared video, Gypsy details a plan where their future daughter would lose her virginity to Go John at age 13, claiming this was the way it has to be, which that is extremely creepy and disturbing, and illegal. So anybody's talking about fantasies like that, especially if she's out and has kids of her own, people are concerned. As I said, not denying any manipulation or abuse that she may have had, maybe happened, maybe didn't. I'm just learning about it. Still, this, the smoke is cleared, and this is the result of it. And violence and crime. She explicitly states that she is willing to do anything with him, including murder, rape, and she is not scared to push boundaries with getting in trouble with the law, allegedly, and theft. Other clips show her instructing Go John on how to steal without being caught and showing off items she allegedly stole for their future children. And there's always say you have a leader, we talk a lot in politics. And also I use movies and fantasy shows as an example, is that you could have a leader there, but there's somebody pulling the strings behind the shadows. We talk a lot of conspiracies about, Illuminati, aliens, stuff like that, and you can have a possible, a person there, but someone pulling the strings in the shadows. You had, for instance, Star Wars with Darth Vader, that Palpatine was manipulating him to eventually crack and do what he did, but although he was guilty of of the crimes he committed, still there was the sinister one in the shadows that was trying to do a plot. Right. And then the significant controversy. Moki says, I use different stuff, but I like Dove. I think my grandparents used Dove. I used that soap before. Now we're talking about shampoo. I'm sure there's a shampoo for it, but Dove soap is what I've used before. The bar soap. Alright, significant controversy. These videos have fundamentally shifted public discourse around her case in 26. Contradicting the narrative. Critics argue these clips prove Gypsy was an active, manipulative architect of the murder and subsequent criminal plans rather than passive victim. Awareness of truth. In several videos, she admits to Go John that she can walk and has been lying about her age and health to get free stuff, directly contradicting the claims that she was unaware of her own medical status. Gypsy's response. Gypsy has stated she is not proud of the videos attributing them to extreme trauma, coerce, control, and emotional dependency during a dark period of her life. Yeah, so that is some controversy in the modern times about her behavior. All right, and there's concern regarding Gypsy's intensified due to release of previously sealed evidence, and her transition into motherhood. Public opinion has notably shifted, widespread sympathy and skepticism and alarm. Yeah, and of course people are innocent until proven guilty. And as I said, hopefully she doesn't do anything and just lives a normal life, as normal as possible. That whatever in her past could be left behind, she could continue into a more positive future. But people online are just kind of like the town crier, so to speak, or just a warning, a disclaimer about how there's just ethical concerns about her being released, having kids, etc. That could something happen again, as we said, people can repeat offend. And that is what many have reacted to over time on the platform. Now, many critics argue the video proves she was an calculated architect of the crimes rather than a passive victim following Gojan's lead. Some footage she admits that she can walk. Since the birth of her daughter, Aurora, on December 24, Gypsy's parenting has been under intense public scrutiny. Online followers have criticized her for using baby carries incorrectly, leading to fears of suffocation risks. And with you want to having a baby is probably one of the biggest jobs on earth that people have to go through that have kids. It's also very expensive. So naturally, if someone is a criminal or not, if someone is an influencer and they see someone not doing the carrier, whatever it's called, a carrier or whatever, handling a baby incorrectly, people are going to be concerned. So a lack of experience, obviously, people would want them to have the baby taken care of properly. And see, Gypsy has explicitly denied that Child Protective Services is involved. Rumors of wellness checks circulated in early 25 following a live stream where she appeared intoxicated while caring for her own newborn. And that goes to say criminal history or not. You have people that do that, especially on social media. Or, say, back in 20 years ago, it would have been on TMZ. All this would have been on TMZ. And there would have been backlash with that. So that's timeless and would happen to anybody. But that was doing these kind of things. All right. The vicious cycle fear. Some experts and critics express concern about her ability to parent effectively, given her lack of healthy material role model and extreme psychological trauma she endured. Critics worry that her status as an influencer glamorizes criminal behavior, rewards murder with celebrity and profit. And that's across the board, going back to even Ted Bundy and people like Charles Manson, that they get a celebrity status in the media, which happens, pretty much to everybody that is in the media. But of course, they don't want that kind of behavior to be rewarded for people that might be depraved minds like her. Accountability. There is an ongoing debate about disparity in sentencing between Gypsy, who served 8 years, and Gojan serving life, with many now believing her accountability was insufficient. Oh, okay, Mermaid. Understood. Thank you for letting us know. And thank you, Mermaid, for suggesting this case. Yeah, the tables have turned. Right. And we are looking, into updates and exposing the situation. Yeah. Mental health and social media behavior. Gypsy's behavior on social media has been described as erratic, including frequent feuds with critics and leading accounts, and advice of her parole officer to avoid legal trouble. Experts suggest that internet might not be the best place for her recovery, as constant spotlight may be hindering her genuine emotional healing. All right, we're going to pin this right here. Love you all. I'll be back later. Enjoyed the Gypsy Rose place, and I highly recommend watch Becca Scoops too if you want to follow this case. Yeah, Becca Scoops has some very good content on this case that I've seen on YouTube that Mermaid has recommended. And for those that are interested, that's another YouTuber to look at that has good takes on this matter. Gypsy Rose has a daughter now and talked badly about having a daughter when she was convinced Nick and her mom it's weird story. Yeah. Absolutely, I agree. Now, during the time. Oh, you're welcome, Mermaid. And I'm going to make videos about this also. And as I tell you, Mermaid, we're going to be covering the Epstein stuff too soon. We're still watching the OJ trial also. But of course, we're going to do the other streams that we usually do as well. I've been really enjoying the OJ trial watching. That's been really cool. I appreciate all y'all's recommendations and suggestions. It's been a very cool experience. Yes, I do agree with you, Mermaid. She looks very good for age. Yes. And she's a good YouTuber, and I like her content as well. And you're welcome, glad to have the suggestions. Yeah, and I like how she did her channel and was exposing these things because people need to know about this, I think. Just to be, as a word of caution, and to be aware of these people repeating again and just discussing about what could be or what cannot be. It's a good group discussion in general, I think. While she was on... Oh, yes, Mermaid, yeah. Oh, okay. Well, Mermaid, I look forward to seeing it. And very good job, Mermaid, on your video yesterday. It was amazing. Very good video. Right. While she was on parole, however, the legal ramifications for the violations were severe due to her original 10-year sentence, degree murder. Had a violation occurred before June 25, the potential ramifications included parole revocation. The Missouri Department of Probation and Parole could have revoked her parole entirely, requiring her to return to prison to serve the remainder of her original sentence. Re-incarceration, because she was released after serving 85% of her sentence, roughly 8.5 years. A major violation could have sent her back to prison for the remaining 1.5 years. Stricter conditions. Minor technical violations, missing a check-in or unapproved travel could have resulted in house arrest, increased monitoring, or mandatory extension of her parole period. New criminal charges. If the violation involved a new crime, she would have faced new legal proceedings and potential additional jail time on top of revocation of her existing parole. During her parole period, Gypsy was subject to strict rules that sparked public debate. No contact with felons. She was prohibited from associating with known criminals, which included direct or indirect contact with co-defendant Nicholas Gojan. Social media restrictions. Her parole officer reported he monitored her online activity closely. Early 2024, she deleted several accounts on her officer's advice after public clapbacks and disputes. Her flag is potentially erratic behavior, residency, and travel. She was required to live with approved family members, originally her father, stepmother, and needed explicit permission to travel across state lines. Now that her parole is complete as of June 25, she is no longer subject to these specific conditions or threat of summary incarceration for technical rule breaking. 2024, 2025, Gypsy Rose Blanchard's social media behavior was characterized by a cycle of viral stardom, intense public backlash, and multiple deletions of her accounts. Post prison stardom, early 2024. And this is some more about her online behavior. Following her release, December 23, Gypsy gained nearly 20 million followers across TikTok and Instagram. First, selfie of freedom. She posted photos of herself in mirrors and celebrating with her then husband, Ryan Anderson, stating she wanted to enjoy social media like any other person. NSFW personal comments. She famously defended her husband from online trolls in the comment sections of her Instagram, making candid and cringeworthy remarks about their intimate life, which went viral. Deletion and guidance, May 2024. In March 2024, Gypsy suddenly deleted the public Instagram and TikTok accounts. Parole officer involvement. A source confirmed that deletion was the advisement of her parole officer to prevent her from engaging in behaviors that could risk her freedom. Doorway to hell. Before deactivating, she released a video calling social media a doorway to hell and stated she did not want to live her life under a microscope. Controversial content, mid 24 to 25. Mother's Day post, May 2024. She sparked significant controversy by posting and later deleting a message about her mother, Dee Dee, stating she wanted to honor memory despite the abuse. Feuds and DMs. In June 2024, she shared screenshots of death threats and she received using her platform to highlight the hate she faced since her release. Rebranding and pregnancy, late 2024 and 2026. By late 2024, Gypsy rebranded her pages to focus on professional advocacy and her pregnancy. Private life pivot. She announced in November 2024 that she would no longer post personal family content on public platforms to protect her daughter, Aurora. Return to TikTok despite her many permanent deletions. She returns to TikTok in early 2026, though she reportedly handed management of the accounts to her best friend to mitigate direct public scrutiny. The online environment for Gypsy Rose Blanchard shifted from initial support to intense scrutiny and significant harassment. Let's see. She has publicly addressed receiving chilling death threats to her direct messages, some users telling her she deserves nothing but 6 feet under, safety and fears. The level of online vitriol became so severe that she expressed genuine fear of physical assaults in public from haters who too comfortable with their negative feelings towards her. Account suspensions. In early 2025, various formerly known as Twitter, Facebook accounts purportedly associated with her were suspended following reports of violating rules against violent threats. Critics often labeled her a sociopath or narcissist, claiming she leveraged her past for fame rather than genuine healing. Financial, we said that about the money grabber. All right, we said that. Okay. And that is update about Gypsy. It's just kind of an overview about that case. And there's been let's see this. Yes, as I said, that is the case about that. And let's see some other trial updates. Chrissy said, so Pentene makes you DM. I don't know what that is exactly. But let me explain a little bit further. Okay, thank you. So, some other trials that we've been covering. Okay, Chrissy. Good night to you. Love you too. All right. Thank you for coming. Term, let's see, the crime on November 2020, too many 20s. November 20th, 2018. Keith Canero, 50, and his wife Jennifer. Oh, facts. Facts, Chrissy. And their two children, Jesse, 11, and Sophia, 8, were murdered at their home in Colts Neck, New Jersey. Keith was found shot outside. The others were found inside the burning mansion, having suffered homicidal violence before the fire was set. The suspect, Keith's brother and business partner, Paul Canero, was charged with 4 counts of first-degree murder. Motive: prosecutors allege that Paul deleted his brother's family after Keith discovered Paul was stealing from their business. And also, Chrissy says shout out to Miranda too. Facts. Paul was stealing from their business and attempted to cut out financially. After years now, we are doing the trial again. Not forgetting you, sorry, I'm trying to move around. Oh, okay, understood. Well, I appreciate you giving Miranda and I a shout out. It was nice, chatting with you tonight. All right, key testimony and evidence, January 21, 26. Someone just got whacked. Dr. Dennis Corpora, a neighbor of the Colts Neck mansion, testified that he was awakened by a series of 5 or 6 gunshots around 3:20 a.m. morning of 2018 murders. He recalled telling himself at the moment someone just got whacked, and subsequently called 911 at 3:33 a.m. Surveillance disconnected. Captain Brian Weisbrot of the Monmouth County Prosecutor's Office testified regarding surveillance footage from Paul Carino's own home in Ocean Township. The video showed a man walking toward the digital video recorder DVR system in 2:28 a.m., which the point the screen went from black and the system was manually turned off. You are an angel multitasking. And we can see that. So your mistakes are forgiven. All right. Trusted attorney testified about $3 million life insurance trust established by Keith Canario prosecutors allege Paul, the sole trustee, stole approximately $78,000 from the account and murdered his brother's family after Keith discovered the theft and threatened to expose him. Paul Canero is charged with first-degree murder and his brother, sister-in-law Jennifer, two young children, January 12. All right, so that is that update for that trial. Let's go here. Oh, okay, Chrissy, I hear you. I don't know anything about the shampoo personally. All right, the au pair love triangle. As of January 21, 2026, the murder trial of Brendan Banfield is currently underway in Fairfax County, Virginia. Banfield is accused of masterminding a plot to murder his wife, Christine, and Joseph Ryan to facilitate a relationship with family's former au pair, Juliana. The defense case begins on January 21. The defense began calling witnesses after prosecution rested its case. Motion to dismiss denied. Judge denied a defense motion to dismiss the charges. The defense argued that Juliana's testimony was unreliable and DNA evidence did not implicate Banfield. The Anastasia 9 dispute. Prosecutors claimed that Banfield used fake profile Anastasia 9 on the fetish website to lure Joseph Ryan to his home after arranging the grape fantasy encounter. However, a former digital forensics examiner testified in defense that his analysis suggested Christine Banfield may have actually controlled the account herself. Right, so I think that it's a very wild trial, and Judge Penny from the Depp trial is overseeing the trial, so that's like a little nostalgia. That's the first trial that I saw. Medical testimony. The prosecution called Christine's father to testify about a lifelong blood disorder she had. This was used to counter defense claims that she engaged in knife play as her condition made her prone to excessive bruising and bleeding. Juliana's family former oh, Chrissy, that's wild. That's wild. And Mermaid would get it. Yeah, okay. Is Joe in this trial? The name is Joe and Christine. Yeah, I remember you were talking about that. It's wild how there is so many people where these synchronicity things happen. It's almost like a coincidence. Yeah, scared. Yeah, the killings of Christine Banfield, Joseph Ryan. Yeah, it's a spooky, Chrissy indeed. Yeah, scared. Plea deal. She previously pleaded guilty to manslaughter for the death of Joseph Ryan, agreed to testify against Banfield as part of cooperation agreement. Testimony. During the first week of the trial, she detailed the alleged year-long affair and plot she claims Banfield orchestrated. And Chrissy says, I really hate to hear it. Oh, Miranda, where are you? Scared. Oh, and Miranda is busy with some things, but she came and told us hello for a moment. Maybe she'll be back later. But shout to her, definitely. And she's doing some work. During the first week of trial, she detailed the yeah, absolutely, Chrissy. Yes, definitely true. During the first week of the trial, she detailed the alleged year-long affair, the plot she claims Banfield orchestrated to avoid an expensive divorce. She admitted to shooting Ryan after Banfield shot him first, and she claims she saw Banfield stabbing his wife. The case stems from February 24, 23, the killings of Christine Banfield and Joseph Ryan in Henderson, Herndon, Virginia. Banfield and Julian initially reported the incident as a home invasion where they shot a predator in self-defense. Investigators later determined the scene was staged. I'm scared. Alright, so that is the update for the Opar trial, and the two other ones in Uvalade was a not guilty. That happened earlier? Okay. All that's over with. Alright, let's go here. Let's look at something. Alright, now we've completed the topic of Gypsy and the trial updates. Now we'll play some of the OJ trial for a little while, and then we'll end it. Okay, let's go here. Let's go down this way. All the way. Alright, now switching over to the other window. Here we go.
They were seized.
I'm not sure. I don't know if they were photographed when Mr. Yamaguchi first did a blood search on them or not.
When did he first do a blood search on them? If you know.
Off the top of my head, I don't know, and I wouldn't have those notes with me, I believe.
Do you have a rough idea what month it was?
Let's see, I did my... It would have to have been before I did my examination of on September 18th, so it would have been in either August or September.
Should you take pictures of an item of evidence when you're going to alter it in some fashion, both before and after you do the alteration?
That is a good practice, yes.
When you took cuttings of those socks on the 18th, did you have any pictures taken before you altered them?
No, I did not.
Did you have any pictures taken after you altered them?
Not at that time, no.
The pictures that were used here, I believe yesterday, for you to identify, when were they taken?
They were taken at some later date at one of the other laboratories that worked on these items.
All right, Mr. Blasey, which item are you referring to? It was the picture of the socks.
A and B.
14A. One of the policies that is in place in your lab is that items, when they come into the lab, are photographed so that you can preserve their appearance and their condition when you first get them. Isn't that correct?
No, it is not.
Do you think that's a good practice?
The items are photographed in the scene. It shows their appearance at the time they're collected. We do not then photograph them again as soon as they come into the laboratory.
Why not?
Well, it's a combination of it is not necessary, and we deal with large quantities of evidence. It's a matter of practicality.
Now, representatives of the defense have been at the lab a number of times, correct?
Yes, they have.
And every time someone from the defense has been at the lab to look at an item, it has been extensively photographed by your photographer, correct?
Yes, that's correct.
Both before we look at it and after we look at it, correct?
Yes.
When you conduct examinations of evidence yourself, when we aren't there, do you photograph what you do?
Not every item, no.
How do you decide which ones to document by photographing and which ones not to?
Historically, as a rule, very few items are photographed within the laboratory on a regular basis. At this point, well, it still is that many times the evidence items are not photographed.
Can blood on clothing change over time in terms of your ability to extract information from it?
Yes, particularly depending on its storage conditions.
When you decided to do a blood search on the 29th, did you give anybody any instructions that we should do this fairly quickly?
No.
Can you estimate the number of months it was from the time those socks were collected until someone looked at them carefully?
It would have been 2 to 3 months, something like that.
On the 29th, where you evaluated the evidence for purposes of possible testing, your notes indicate that the various items that were examined very carefully, including the measurements of each individual swatch, weren't they?
Referring to my copy of those notes, we have measurements, yes, indicated under the quantity area on each of the swatches.
Is it accurate that this was not just a brief meeting in passing, that this was a meeting that you took some time to carefully review these items?
It took quite a while to do this inventory, yes.
Are you aware of Andrea Mazzola's testimony in August to the effect that she wrote her initials on the coin envelopes of the blood drops that she collected?
Sustained.
No, that...
Sustained.
Oh, excuse me.
Would it be of concern to you as a supervisor of criminalists if you reviewed evidence items that, to your knowledge, had originally been signed by a criminalist, and those items were not signed when you look at them?
Argumentative. Sustained. Rephrase the question.
Do you have any method that you use of examining items of evidence at a particular time to see whether it's the same evidence that was collected originally?
We do not have a ongoing formal policy of checking the item that's being examined for, say serology or trace or whatever, against an original proper report or something.
Would it be of concern to you if items that you examined, you expected to have initials on them by the person collecting them and they weren't there?
Argumentative. Overall.
Are you saying that if I received a packing material that had no initials on it?
No, that had initials from somebody other than the person you thought had collected it.
Sustained. As phrase. On the 29th, when you were going through all these items, did you notice anything unusual about the initials on these packing items?
No, I did not.
Hypothetically, if a criminalist had put their initials on an envelope that contained an item of evidence that that criminalist collected, and you later examined that envelope and there was no signature on it or someone else's signature on it, would that cause you concern?
Improper hypothetical.
Sustained.
Not relevant argumentative. Can we approach?
No. Sustained.
Mr. Matheson, I want to ask you some questions about the Bronco. The Bronco was impounded on the 13th, correct?
I was not involved in any of that. I've heard that.
Were you involved at all in any examinations done on the Bronco during the course of the time it was impounded?
No, I was not.
Did you make any effort to follow what the people that worked under you were doing with respect to examining the Bronco?
To some extent, yes, not moment by moment.
But you were reviewing with them the various searches that they did of the Bronco, correct?
I would hear, what items were collected, that type of thing, yes.
Did you review any of those notes as they were prepared?
No, I did not.
Is there some reason why you did not review those notes?
Well, as was previously mentioned, it's still consistent with the notes from both Bundy and Rockingham. I had not received them prior to their being copied and distributed.
To your knowledge, did anybody review them before they were copied and distributed?
Not to my knowledge, no.
When would these reports be copied and distributed? How long after a particular search took place, in general?
Are we talking about in relation to this case or in
This
other
case.
cases?
This case.
Well, as a rule, given some of the conditions, we were trying to get things turned over as soon as possible. I don't know, it depends. I mean, sometimes we were not receiving some of this information until significantly later time.
At some point, did you become aware of the possible significance of 4 small stains on the door or the door sill of the Bronco?
No foundation for personal knowledge calls for hearsay.
Overruled.
The first time I specifically remember hearing about those was in testimony on this case.
So you're not aware at any time prior to that that there was any concern about whether those stains existed or not?
Sustained.
When you say the testimony in this case is where you became aware of that, was that Detective Furman's testimony at the preliminary hearing?
No, it was Mr. Fung's during the trial.
You had no awareness of Mr. Fung being sent out by the district attorney's office to look at that Bronco on July 6th?
Not as I recall, no.
Were you still supervising him at that time?
Sustained.
Were you still in charge of managing the items in this case at that time?
It was one of my tasks to be involved in tracking the items, yes.
Would you agree that it is proper procedure for a criminalist collecting an individual stain to collect the whole stain if possible?
If possible, if it's a very, very large stain, there's no reason to. But if it's a small stain, I'd expect it to be collected.
If it's a manageable size stain, they should collect all of it, correct?
As much as possible, yes.
And the reason for that is you can't tell from looking at a stain how good the blood or whatever it happens to be is going to be in terms of your being able to extract any information from it.
That's correct.
So you try to get as much as you can, correct?
That's correct.
And your people understand that.
I believe so, yes.
Now, when Dennis Fung and Andrea Mazzola searched the Bronco on the 14th, did you discuss, after they were done with that, anything about that search?
I may have gotten a general overview of what was collected, but not in detail, no.
Did Dennis Fung ever tell you after the 14th that he had left a lot of blood in the Bronco?
Sustained.
Did you become aware at any time, let me rephrase that. Did you have any awareness at all after the 14th that blood had, let me rephrase that. When did you first become aware that there was more blood in the Bronco after the 14th?
Was when I saw the console when it was in the serology laboratory.
So nobody had informed you of that fact prior to that time?
It is possible that it was mentioned to me. I believe the search and the collection of the items from the Bronco was on August 26th. It is possible at that point that Ms. Kessler mentioned to me that there was blood present. I did not see any of these items, though, until they were back into the laboratory.
Now, you indicated earlier that it is your practice, or the lab's practice, for continuity to have the same criminalist stay with the case throughout the case if possible.
If possible, we'd try to.
Now, when did Andrea Mazzola stop working on this case in terms of doing searches?
I believe it was following the Bronco search in the shed, but I'm not quite sure.
On the 14th?
I believe so.
Was she available after the 14th?
She was working, yes.
Was she available to do further searches on this case?
I don't know. She works not in one of my units. I wouldn't know at any particular date and time if she was available.
For continuity of the case, isn't it your practice that she should have stayed on the case?
In all of this, it leaves us with the ability to make changes. In other words, in a normal case where we have a crime scene search and then maybe a follow-up scene of one type and that's it, we try and maintain this continuity. However, given the extent and the complexity of this case, at one point we decided to start involving other people besides the original two.
And was she taken off because of her lack of experience?
Sustained.
Why did she not do any further searches in this case?
Because she had duties in her own unit and she was done at that point with this particular situation, and we were bringing other people in that potentially would be being involved with the analysis of the evidence farther down the road.
Now, the search that was done on August 26th, that was done by Michelle Kessler, the head of the lab, correct?
She was one of the parties there, yes.
And the media was invited to that search, correct?
I believe there was a photographer.
Dennis Fung wasn't invited to that search, was he?
I don't know if he's invited or not.
A photographer from Life magazine was invited to that search, correct?
Sustained.
What level of security, to your knowledge, had been provided for the Bronco during the period of time from June 14th until August 24th?
No foundation, personal knowledge.
Sustained. First question.
Do you have any personal knowledge about what security there was surrounding the Bronco between June 14th and August 24th or 26th when that search took place?
No specific knowledge, no.
Now, is there a policy with respect to vehicles in terms of processing them quickly because they are mobile to a certain extent?
I don't know if the reason to process them quickly has to do with any sort of mobility. It would be imperative or important to process any sort of scene quickly, of which a vehicle is one, to attempt to recover any biological evidence that may degrade.
Now, vehicles are not stored in the evidence control unit, are they?
No, they are not.
They're stored at a tow yard, aren't they?
There are two different ways that a vehicle can be brought into the possession of our department and stored. One of them is we have a facility which is under the control of the police department, located behind Parker Center, where we have temporary storage of vehicles, and it's an area where they can be searched. At some point then they're transferred out to a official police garage, or in some cases they go directly to the police garage.
Directly to, I'm sorry?
The police garage, an official tow yard.
This Bronco was moved to a tow yard, was it not?
No foundation for personal knowledge.
Sustained.
When it was searched on the 26th, where was that?
I don't know about on the 26th. I can make an assumption, but I don't know for a fact.
Is it important to process a vehicle, as a general rule, before it is put in a place where there is ready access by civilians?
Well, it's important to perform, excuse me, it's important to perform any search, if you can, before it has the potential of access by anybody that doesn't belong there.
What steps did you take to see that the Bronco was thoroughly and carefully searched before it went to a tow yard, if any?
My understanding was that a search of that vehicle had been performed, I believe it was on the 14th or the 15th of June, and at that point that we were done with it.
So your impression was that everything of evidentiary value had been collected?
I trusted the criminals we had at the scene to make that decision, yes.
And that's the way they should have done it, correct?
Sustained.
Is that the proper way to do it?
It is what the proper way to do it.
When you go to search the vehicle, to do it all at one time if you can, be thorough, get all the evidence that's there, so you don't have to go back.
Of course, the best thing to do is get it all the first time.
And it's not desirable to have to go back a second time to a vehicle or any place to collect evidence that you missed the first time, is it?
If you can avoid it, sure, it'd be nice to get everything the first time every time. Occasionally, though, we do have to do repeats.
Now, I'd like to show the witness a form.
Blazier?
Mr. Madison, do you know what the term special care means with respect to a vehicle that's been seized?
Not that specific term, no.
Are you aware of any procedure that LAPD has in effect to provide special care to vehicles that have been seized?
No foundation for this witness's knowledge.
Overruled.
Well, I do, excuse me, I do know that the garages that the police department use to store vehicles have areas that are designated as print sheds or what are supposed to be more secure areas than just their lot, so that they're maintained until our arrival for searching.
Let me show you this form again, ask if you're familiar with it. I'm sure I didn't get a chance to look at it.
It's the form, it's nothing he created or his laboratory.
Overruled. Do you recognize the form?
I recognize it by its title as being a Los Angeles Police Department Vehicle Investigation Form. I've never utilized one of these.
All right, do you recognize the information? Are you familiar with the information that's on that form?
Information regarding the form itself, or what is
No.
filled out?
The information that's contained on the form that's been filled in. Are you familiar with that information?
Oh, I recognize notations regarding this case and the.
Thank you. Mr. Blazier.
Are you familiar with the procedure that the Los Angeles Police Department uses to release a vehicle that they're done with?
No, I am not.
I have a couple of pictures I would like to have marked.
All right, 1128 and 1129.
Actually, I have 49.
1130 and 1131.
I'm sorry, what's that first number, Your Honor?
1128.
Those marked A through
1128, 1129, 1130, and 1131. And generally, what are these, Mr. Blazier?
These are pictures of reference blood vials for both victims. Madison, let me show you first 1128 and ask if you recognize the blood vial in that picture.
Yes, I do.
And let me show you 1129, see if you recognize that.
I believe it's the same one.
And what are those pictures of?
Of item number 60, which I believe is Mr. Goldman's reference blood.
I'll show you 1130 and 1131. You recognize those, and what are they?
These are both photographs of two sides of item number 59, which I believe is Ms. Brown's reference samples.
Mr. Matheson, do those two pictures appear to be accurate pictures of the reference blood vial for Ronald Goldman?
Yes, I do.
Now, reference blood from victims is taken by the coroner, correct?
That's correct.
That's not a function of SID, correct?
That's correct.
And after it's taken at the coroner's office, it's transported in some fashion to SID, correct?
Yes.
Now, you will agree that there is blood on the outside of that vial?
Yes, there is.
There is a substantial amount of blood on the outside, isn't there?
Yes.
Do you know how that blood got on the outside of that vial?
Not specifically, no.
When blood gets outside of a vial, would you agree that it is more likely that it can contaminate things?
Something comes in contact with it, sure.
And it's like a hand would come in contact with it. You could have some transfer of a small amount of blood from the vial to the hand, correct?
That's correct. That's why I'd wear gloves if I was to handle this item.
A small amount of blood that you might not even be able to see.
Possible, yes.
But there would be enough blood to test and get a result on using DNA testing, correct? Are you aware of how much, well, let me withdraw that. Let's take a look at 1130 and 1131. and 1131, those are pictures of Nicole Brown Simpson's reference vial, correct?
Yes, it is.
And that would have been taken from the, originally taken from the coroner's office, correct?
Yes.
Would you agree that there is blood also on the outside of that vial?
Yes.
Do you know how the blood got on the outside of the vial?
No, I have no personal knowledge of that.
When you use these vials to perform tests on them, do you pour blood out, or do you use something like a pipetter to take blood out?
You take it out with a pipetter.
You don't take it out in a fashion that would cause it to spill on the outside of the container, do you?
Try not to.
And to your knowledge, does the coroner follow the same procedure? If they need to take a withdrawal, they use pipetters as well?
I don't know the procedures that they use.
When are criminalists supposed to write reports of testing that they do with respect to when they do the test?
The final report?
Any report or notes?
Well, the notes, some of them are going to be completed as the work is done. At some point after that, upon the completion of the analysis, the notes or the summary is going to be brought together to make the report.
Is it acceptable procedure within your department for a criminalist to perform a test in July and not make any record of it until October?
That would be unique.
That would be bad, wouldn't it?
But
Sustain, phrase the question.
That would be unacceptable, wouldn't it?
I would want to know why that much time passed.
Now, you're aware that that happened with respect to a test that Dennis Fung did on the Bronco on July 6th, are you not?
I know that there was some information that was provided in a report at a later date. I don't specifically know which one you're talking about right now.
What effort did you make to find out about it, like you said you would?
Seems facts not in evidence, also beyond the scope.
You mean to find out why it had taken that long?
Yes.
Well, if I received a report after that amount of time, I would just ask them why it took so long to get the information down on a report.
What'd you find out when you made that inquiry this time? If you made an inquiry.
It's an improper hypothetical.
It's not a hypothetical. Did you make such an inquiry with regard to this report?
I'm not specifically remembering which report we're talking about. So
Well, let me make it more specific. A pheno test on purported or alleged stains on the bottom of the Bronco door.
Would it be possible for me to review that report?
Find that later.
Is it proper procedure when you do a pheno test on something such as a car to photograph it before you do the test?
Sometimes we do and sometimes we don't. As an explanation for that is if I see a stain and I don't know whether or not it is blood, I normally will not photograph it first because if it's not blood, if it's not something of interest, then it won't be collected. And thus it's not evidence. There's no reason to have a photograph of it. If it is something that I know I'm going to be collecting, there's a very good chance I'd have it photographed before performing the pheno test on it.
What if it's something that you suspect you're going to be collecting, and that's why you run a test on it to begin with?
Overruled.
Shouldn't you take a picture first?
Overruled.
If it's something that I suspect that I'm going to be collecting, I mean, because we do a lot of spot tests out in the field. If I found a blood stain or a stain that I suspected of being blood, and many times you can tell just by looking that it's probably blood. Again, it depends on the situation. If it is a very small sample and I was going to be consuming a large portion, first off, I wouldn't want to necessarily run a pheno, but if I felt it was necessary, it would be a good idea to document it first. If it's a larger sample, larger item, and by removing a small portion and running my test is not going to make any significant alteration to it, then no, I wouldn't necessarily do it. I might.
Well, let me give you a more detailed hypothetical. Suppose a prosecutor sends you out to look at something because a detective said, there's blood there. Go out, look at it, see if it's blood, come back and tell me. Would you document that by way of taking a photograph?
Sustain.
Is it proper to do a pheno test on an item and take a picture after you do the test while the stain is still moist from the pheno test?
Overruled.
I don't see any problem with it being moist from the test. As I mentioned before, I laid out the reasons or the times where I would have a photograph taken, and that is if I ran, let's say I had a stain that I didn't know whether or not it was blood, and I ran my pheno test on it and it turned out that it was blood and had it photographed at that point, I wouldn't worry whether or not that it was damp from the
Other jurors, please.
it's just limited to being mixed or come in contact with other biological materials. You can get contamination of non-biologicals too.
But a non-biological item is not going to change the blood type, for instance, of a blood sample, correct?
That's correct. Neither will a biological contaminant.
Well, are you saying that there are no circumstances where one biological material getting in with another can change the type of that material?
It will not change the type of the material, no.
How about the test results when you test it?
Depending on the degree of contamination, yes, it could change the results of the analysis.
Now, is it important to have procedures in place to prevent contamination in the collection, packaging, handling, and analysis of evidence?
Yes, it is.
Do you feel that additional protections are necessary when you are considering doing DNA testing such as PCR amplification?
I believe the only additional controls or process that would be necessary is that the person be aware that it takes a very small amount of sample to give a PCR result.
When you say a very small amount of sample, how much are you talking about?
Well, I don't know, as far as exact size or weight. I believe it's something you'd have to be able to see when it comes to forensic analysis.
Is it your understanding that only biological material that you can see can be typed using PCR?
I'd say when we're talking about blood samples, I am not aware of the fact that a blood sample that is invisible to the eye would be typable by the procedures used in forensics.
Mm-hmm. How large a sample, in your experience, do you need to type using PCR?
I have never performed tests or anything on, to determine the quantity.
During the years that you spent arranging and helping to set up your lab, you never learned anything about the quantities of DNA necessary for conducting tests?
Well, I oversaw the process. I wasn't actually in there hands-on working with them, establishing the procedures. I have heard over the years figures given as far as how much DNA is necessary to get a result. Off the top of my head right now, I don't know what those are.
Do you know what a nanogram is?
Yes.
How much is a nanogram?
I believe that's a billionth of a gram.
And a gram is about 1/500th of a pound, approximately 1/454th of a pound, correct?
I don't specifically know the number, but that seems it would be about right.
So if you took a pound of something and cut it up into 454 pieces and then took 1/100000th of one of those pieces, that's a nanogram, correct?
It's a very small amount, yes.
And what amounts, what's your understanding in terms of the minimum amounts of DNA required to do typing?
Well, my understanding in general is that in the low nanogram level is typable.
1 or 2 nanograms, correct?
Of DNA, yes.
Is it your understanding that you can see 1 or 2 nanograms of DNA in a blood sample?
Not the DNA itself, no.
But that a sample which would contain only 1 or 2 nanograms you can see?
I believe so, yes.
How big is it?
It's a very small spot.
About the size of, I'm sorry.
No, I'm sorry, go ahead.
About the size of a pinhead?
It depends on the pin, I suppose, but yeah, a very small point or tip of it.
Far smaller than you need to do any kind of conventional serological testing, correct?
Definitely.
And can you tell me, in your lab, what procedures with respect to collection, packaging, handling, and analysis of evidence have changed since you started doing DNA testing?
The only thing that has changed has been we've tried to make the people aware that it's a very sensitive test. The actual procedures themselves have not changed in that we still just use clean tools. We wipe them off with a dampened tissue or something like that and avoid contact with other items.
Have you done any studies on whether the procedures that you use to collect serological samples for conventional serology are adequate to guard against contamination when you're considering doing DNA testing?
Did you say any studies?
Yes.
No studies specifically for that.
Your Honor, I'd like to show one of the charts that we had talked about before.
Proceed. No. 1132.
1132. Mr. Matheson, can you see that chart from where you're sitting?
Yes.
Now, that chart indicates 20 nanograms is approximately the size of a pinhead. Is that your understanding, or is your understanding that 2 nanograms is the size of a pinhead?
Well, I'm not talking, specifically about quantities, and there you're referring to, I'm assuming, the amount of DNA. 2 nanograms or even 20 nanograms of DNA would not be visible.
Did you say earlier, though, that you thought 2 nanograms in a blood sample would be visible?
Oh, as far as in a blood sample, I believe that my understanding is that using the forensic techniques, the amount of DNA found in a blood stain or something, that you would be able to see it. It'd be very, very small, but you should be able to see it.
Now,
Mr. Blanchard, do you want to move that exhibit down towards the end of the box so the other jurors can appreciate the comparison? Slippery, isn't it? All right, and why don't you give the jurors the opportunity to examine that? All right, thank you, Mr. Douglas. Mrs. Robertson, 1122? 1132.
Mr. Matheson, how much is a microliter of blood?
A millionth of a liter.
And you know how many nanograms of DNA there are in a microliter or a millionth of a liter?
Not off the top of my head, no.
Now, the technique that is used in your lab, called PCR, I'm not going to ask you a lot of detailed questions about this, but basically involves taking a very small amount of DNA and multiplying it into a bigger amount. Is that an accurate, rough description?
A specific portion of that DNA, yes.
And by a specific portion, you mean a particular section of the DNA chain.
That's correct.
And just like the enzyme systems that you were talking about yesterday have genotypes, DNA has genotypes as well, correct?
In the systems we're looking at, yes.
And it's the same kind of structure in the sense that we inherit half of our DNA from our dad and half from our mom, correct?
That's correct.
And it's the same kind of inheritance process that's going on that accounts for 2 different what are called alleles, one from each parent, correct?
True.
So, for instance, in the EAP system that we were talking about yesterday, when you describe somebody as being a BA, that tells you that they got the B allele from one parent and the A allele from another parent, correct?
That's correct.
And in the PCR system, the genotypes work the same way in the sense that there are two numbers associated with any particular genotype, one which came from your father, one which came from your mother.
That's correct.
Now, in the EAP system that we were talking about yesterday, when you say that somebody is a B, what that really means is that they got a B from both parents. So it's in essence a BB, correct?
True.
Now, the DNA in a person's saliva, for instance, is the same as the DNA in their blood. You're aware of that, are you not?
Yes, I am.
That every cell in the body that has a nucleus has DNA in it, correct?
That's correct.
And it's all the same for one particular person.
Yes.
And the tests that are done, the PCR tests that you do in your lab, are incapable of telling the difference between DNA, which comes from saliva, as opposed to DNA, which comes from blood.
I think at this point it's going beyond the scope of the direct.
Sustain.
Now, Mr. Goldberg asked you questions yesterday about DNA floating in the air. And I believe you said you weren't aware of that happening. Is that correct?
Well, misstates the testimony.
We were talking about clouds of DNA floating around,
Yeah.
I think. In general, yes, that's correct.
What happens when you sneeze in terms of DNA? Do you know?
Yeah, well, if you don't cover your mouth open and you sneeze just in the open air, some of what comes out is going to be saliva and other constituents, and that is going to have cells in it, which is going to have your DNA in it.
And if you're standing over something like a podium and dead skin cells fall off your skin, that has DNA in it as well, does it not?
I think this is still beyond the scope of the direct.
I think we're still on the issue of contamination here.
Correct.
I don't know to what extent dead skin cells have DNA in it.
Do you know what a wipe test is?
I know it's used in a couple of different contexts.
What's the context that you know with respect to DNA testing?
What I've heard of on that is to wipe down the counters of a work area, then extract that wiping and amplify it and analyze it for DNA types.
And wiping down a counter which may not have anything apparent to the eye on it might have DNA in it, correct?
This is beyond the scope of the direct.
We're getting there. We're real close here because this is specific to PCR testing. And this person was not presented as a PCR witness for the prosecution. I think you've established what the issue is here. Proceed.
Can saliva from one person, if it gets in a blood stain on the ground, result in the first person's DNA showing up in the blood stain?
If it's of sufficient quantity, yes.
And if the blood stain on the ground has deteriorated because of humidity or environmental conditions to the point where there is not a lot of DNA in it, and is contaminated by saliva from perspiration, for instance, from somebody leaning over it, that person's DNA type would show up, or could show up, rather than the actual type in the blood, correct?
If, as you say, the original blood stain had deteriorated completely to the point where you could not get any results from that, that's correct.
And that's called contamination, isn't it?
That's a type of contamination, yes.
And the type of tests that you do are incapable of telling the difference, in my hypothetical, between DNA that comes from perspiration of the person standing up as opposed to the blood of the person who deposited it.
Beyond the scope.
I'll allow this one issue, but I think we need to move on. Is that true?
The DNA test cannot tell the difference, that's correct.
All right, let's proceed.
You know, I'd like to show the other chart we have.
All right, 1133.
Now, Mr. Matheson, the amplification process that you go through when you do PCR test involves taking a small amount of DNA and doubling it in what are called cycles, correct?
Yes, that's correct.
And typically that's done 32 times, correct?
That's the protocol in forensics, yes.
And that chart depicts that starting out with a very small amount and doubling it 30 times leads to a very large amount, correct?
Doubling at 32, yes, it's an extremely large number.
Well, at this point, I don't think there's any foundation laid for the chart, so object to it.
This is chart 1134. And Mr. Matheson, is it accurate that with PCR amplification that we've been talking about in general terms, that if you have DNA from more than one source, the amplification process amplifies both sources?
That's
Correct?
that's correct.
There's no way to separate one source from the other,
This is beyond the scope of the direct.
correct?
That's correct.
And just like my example with saliva contaminating a blood stain, you can have flakes of blood from one stain. If it gets on a second stain, that can also contaminate the second stain as well, correct?
If it's in sufficient quantity, yes.
And if it's insufficient quantity to amplify, if the second stain is amplified, the component that came from the first stain gets amplified as well, correct?
Well, it gets amplified as well, but it depends on, there is a point at which in the dilution, or if you have significantly more of one type of DNA than another, the one that exists in the larger quantity may be the only one that you see.
Mr. Matheson, with respect to your last answer, would you agree that the manner in which, in terms of final quantities of DNA that you get with the amplification I described, is really beyond your area of expertise?
It's getting there, yes.
Okay. Now, you have testified, I believe, that you do not consider it necessary when dealing with biological stains that might be subjected to DNA testing to change gloves between each item that you handle. Is that correct?
Not just as a matter of rule to automatically change it between each item, that's correct.
Do you remember, actually it's the same visit we were talking about before, on August 26th to your lab by various representatives of the defense? That's probably the wrong date. Do you remember the date when Mr. Regal, Mr. Neufeld, Dr. Lee, and several others came to the lab for a tour that you talked about before?
Not off the top of my head, no.
You recall a meeting with just Mr. Regal and Mr. Neufeld?
Yes, I do.
Okay. And at that particular meeting, they examined some items of evidence, did they not?
There were a number of items that were examined in the serology lab, I believe.
Approximately how many items were examined? Roughly.
I don't recall. For that, I'd like to take a look at if I have any notes on that date.
Sure.
Do we have any idea when that date was?
I thought it was in August, maybe around the 19th.
Oh.
Well, counsel, let's move on. Rather than have the witness search through his notes, let's focus on what we need to go with.
There were more than 15 items examined, weren't there?
Yes.
You changed your gloves between every single item, didn't you?
I don't remember. I might have.
And you changed the paper on the table between every single item, didn't you?
Like I said, I might have. I don't specifically remember doing it.
Is that the procedure that you use when representatives of the defense are there?
Oh, well.
That was, if in fact I did that, and it's entirely possible that I did, yes, we were being hypersensitive at that point to the handling of all these items.
But when you're doing handling of items in the privacy of your lab with no defense people watching you, you don't follow that procedure, correct?
I do not change my gloves after every time or change the paper every time unless there's some indication such as the item coming in contact with the paper or there being a chance of transferring the evidence.
So it's only if you become aware that you may have touched something that it becomes important to change gloves.
There's a chance that you are going to cross-contaminate, yes. At that point, you'd want to change gloves.
Now, your laboratory has an extensive division order in the field manual that we've been talking about, and I'll refer you to page 125 if you still have that there. You have an extensive procedure that's to be followed with respect to handling possibly contaminated evidence in the lab, correct?
Well, this is vague now as to how he's using contamination.
Sustained.
Let me,
Hearsay at this point as well.
material that may contain infectious diseases.
We do have a division order relating to that, yes.
And the reason why you want to be careful about that is because you may ingest something of an infectious nature from some evidence that you might have collected, correct?
This isn't relevant. It's beyond the scope.
Oh, well.
All of the controls are in place to prevent the operator of coming in contact with the blood. That's correct.
Because if you come into contact with it, it may get into your system and make you sick.
The potential exists, yes.
The same kind of transfer can happen with DNA from biological samples, can it not? With the exception it doesn't make you sick.
I'm sorry, I don't understand the question.
The same kind of transfer in terms of getting something on your skin or on your glove or on your clothing can happen with respect to small particles of DNA or biological material that contains DNA, as with infectious disease materials, correct?
Do you understand the question?
I believe so.
Right.
If what you're saying is can these items still come in contact with your clothing or whatever and not make you sick, and yes.
And if they come into contact with your clothing and your gloves, they can then come in contact with other items that you might touch, for instance, other evidence items.
Oh, well. Do you understand the question?
I think so. The whole idea of wearing these things is if something happens to get on you, it doesn't come in direct contact with your skin. If you're wearing gloves, then what would have come in contact with your skin has now come in contact with your gloves. And then if you use those gloves to handle something else, the potential exists for transferring it, yes.
Now, when you are handling biological materials that may be subject to DNA testing, you do not use the same precautions that you use when handling materials that you may suspect have the potential of having infectious diseases, do you?
Well, we're still wearing gloves, and we are not going with those gloves in areas where we shouldn't. If there's something on them, then we change them and put on clean ones.
So you're saying you do follow the same procedures?
I'm not sure exactly which same procedures you're talking about.
After you handle biological material in the evidence processing room, on that table that we saw in the picture, do you clean the table?
It's brushed off, yes.
With what?
Well, we have, actually, beyond that, the items are wiped down with a solution of water and bleach.
After every item?
No, I don't believe so, no.
And the purpose for doing that is what?
That if there's any residue left on that counter, when you're done with your work, you clean it off. And it's not left there for somebody unsuspecting to come along and become contaminated by it.
Now, is your procedure that you only do that when you can see something there?
No, it is not.
When do you do that?
When you're done working.
So you do not do that between individual items of evidence, do you?
No, we do not.
Do you recognize that you can get a contamination with your evidence materials from things that you can't see?
I still feel that, particularly if you're dealing with, say, a blood-stained swatch or something like that, that if the quantity of material that is going to get on it is so small that you cannot see it, then it is not likely to cause any contamination to that item.
Have you studied the procedures used by any other laboratories that do DNA analysis with respect to the issue of cleaning tables after each item is examined?
No, I have not.
Have you examined any other laboratories that do DNA testing with respect to whether you should change gloves after handling each item?
No, I have not.
Have you studied any other laboratories that do DNA analysis with respect to how you should clean your tools between handling samples?
No, I have not.
Andrea Mazzola testified that she uses, on occasion, serrated tweezers. Is that accurate?
No, that's testimony.
I did hear that, and I believe she said that both serrated and non-serrated were available.
Okay.
Thank you.
Serrated tweezers are tweezers that have little grooves in the end of them so that it's easier to hold the swatch, correct?
Serrated tweezers are not to be used when you're doing blood collection.
Well, did you understand her testimony to be that she does?
That misstates the testimony.
No, I did not.
What did you understand the distinction she made between when she uses serrated tweezers and when she doesn't?
The way I heard it, because I was concerned, was that they were available in the kit, but I'd never heard her saying that she used serrated tweezers for blood collection. That would be inappropriate.
You have anything in writing anywhere to tell your people that the serrated tweezers in the kit should not be used to collect biological evidence?
Not that I know of, no.
Do you know whether that's been communicated to the people that work for you in any fashion at all?
I believe it has, yes.
When?
Can't specifically say it. I pass it on to the people who I am teaching out in the field, and it may be, though I'm not sure, part of training that they've received as far as biological evidence.
Is it your understanding that wiping off a pair of tweezers with a chem wipe, which I think is the procedure you described, correct?
With a dampened one, yes.
With a dampened chem wipe, is sufficient to clean off potential biological material that may have been left over from earlier evidence?
Yes, I do.
Have you done any studies to demonstrate whether that is an effective way to completely remove DNA from earlier samples?
In a way, we're constantly doing a study on that because it's the same process used for our controls.
Have you done any particular studies designed to just find out whether that works the way you think it does?
No.
Are you aware of any scientific articles that say that that's all you need to do to clean your tools between handling items?
No, I do not.
Have you evaluated any other DNA laboratory anywhere with respect to that issue, to find out what procedure is used to clean the tools that's used to handle the evidence?
I have not specifically, no.
Now, I think you testified on direct. You were asked some questions about what are hot topics and what aren't hot topics. You remember that line of questioning?
Do you recollect anything like that?
Hot topics and not hot topics? No.
You're being asked some questions about collection of evidence. In terms of whether particular topics were big topics in the forensic community or not.
Yes, now I do.
And is it your opinion or your understanding that the topic of the collection of evidence for purposes of DNA testing is not a controversial topic in the forensic community?
I believe we were specifically talking about the part that references the actual swatching and picking up. There has not been an awful lot of discussion that I have heard regarding whether you should use water or alcohol or whatever to clean your tools. I mean, it's just not a big thing that's been discussed.
Do you recall an occasion, I believe it was January 18th, when I visited the lab with Mr. Scheck and a few other people?
You were there a couple of times.
You remember the time that we examined the evidence kits that you use?
Yes, I do.
And that was done in the presence of Michelle Kessler, was it not?
I believe she was there, yes.
And we looked at, I believe there were 2 different evidence kits that were put on the table and everything was taken out to look at. You call that?
Well, they weren't 2 different kits. They kind of work together. It isn't like you'd use one or the other one to take out to the scene. In a situation like that, you'd grab both of those particular kits.
Do you remember how, and there were extensive pictures taken of all that, weren't there?
Yes, there were.
Do you remember how we found a scalpel that had been in a sealed container that actually was left open and put back in the kit?
Sustained.
Do you carry scalpels in your evidence kit?
Sustained.
Do you use scalpels in the collection of biological evidence?
If you're going to use a scrape method rather than the swatch that we've described, yes, you do occasionally use a scalpel.
And don't some of your people also use scalpels to cut swatches?
Not relevant.
Yes.
Do you use sterile scalpels?
Yes.
And sterile scalpels come in sealed containers that when you want to use them, you open it up, you use it, and you throw it away, correct?
That's correct.
Would it be inappropriate to take one of those scalpels and put it back in an evidence kit after it's been used?
Improper hypothetical, not relevant.
Sustained.
Didn't we find a used scalpel in one of those evidence kits?
Sustained.
Do you recall you showing us the swabs that are used at crime scenes?
I believe there were swabs in there. I don't specifically remember showing them.
And the bags of swabs, they come sealed with a large number per bag, correct?
Yes.
And when you open those bags, you use whatever you need to use, and then you throw them away, don't you?
On the bags, normally we use them up, yes.
When you don't use them up, do you put the unused swabs that have already been opened back in the evidence kit?
They are still in their original packaging, but yes, they're returned to the kit.
Do you remember when we were there, Michelle Kessler, starting to put those back in the kit, and you grabbed them and threw them away?
Sustained.
Approach.
Proceed.
this document?
What is it?
These are the guidelines for collection and preservation of DNA evidence by the FBI. Mr. Matheson, let me show you a document, Guidelines for the Collection and Preservation of DNA Evidence by the FBI. Are you familiar with that?
I have seen this, yes.
Do you follow that in your lab?
I don't remember all the specifics in it, or if we follow each and every instance that's in here.
Now, this is a document that's put out by the Federal Bureau of Investigation, the United States Department of Justice, correct?
Yes.
And they have a rather extensive DNA program, do they not?
Yes, they do.
And these are guidelines that they put out for the purpose of giving guidance to crime laboratories like yourself on the proper way to collect and preserve evidence if you're going to do DNA testing, correct?
There's only one proper way.
Overruled.
It gives guidelines on appropriate ways to do it, it's my understanding.
And do you accept the FBI as an authority on the proper way to collect evidence for preservation, collect and preserve evidence for DNA testing?
I believe that they are an organization that knows quite a bit about all that, and I would take into account what they have to say.
And you've reviewed that document before, have you not?
I have read it. I don't remember specifics of it right now.
Do you believe that you should videotape a crime scene to show the relative position of all pieces of evidence?
Wait a minute, that's not what it says in this document, and I object to the defense reading from it.
Objection, speaking objection.
And allowed commentary over here as well. Touche. Both sides will be sanctioned. All right, proceed.
I didn't hear the ruling on that.
Proceed. Ask the question. Re-ask the question. He says he's familiar with it.
Let me refer you to page 5. I don't want to misquote anything. Would you agree that the FBI guidelines state that crime scenes should be videotaped with the relative position of the items of evidence before they are touched or moved?
I object under 721.
Sustain. You're still missing one piece of the foundation.
Have you considered the FBI's guidelines in formulating your own opinions on the proper way to collect and preserve evidence for DNA testing?
And specifically videotaping.
No, I have not.
Proceed.
Have you considered the FBI's guidelines, the provisions with respect to identifying evidence items that are collected?
What do you mean by identifying? As far as locating, or?
With a unique identification mark.
I would have to make reference, or be referenced to where it's at. Like I said, I have read it, but I have not committed to memory all the different aspects of it.
Is it fair to say that your laboratory doesn't follow these?
No, I don't believe it is.
Mm-hmm. Can you tell me, let's look at page 6. The provisions with respect to collecting reference blood samples. Do you follow those guidelines?
It's not relevant. They didn't collect the reference blood sample. It's a coroner's.
Well, with respect to Mr. Simpson's.
All right.
Well, we did not collect that.
Do you know whether the Los Angeles Police Department follows the FBI guidelines with respect to that?
No, I do not.
When you get a reference sample from the police department, how many tubes are there in it generally?
Either one or two.
So there's no consistency with respect to the number of tubes?
It's usually one, but occasionally there's more than one.
please refer to page 7. Do you follow item number 4 at the bottom with respect to labeling specimens that are collected for analysis?
Still no foundation under 721.
Sustain.
Mr. Matheson, did you participate in the preparation of the demo tape with Andrea Mazzola swatching a stain?
No, I did not.
Were you consulted before that was done?
No.
Did you have any involvement at all prior to the time that was made in terms of anything involving that demo tape?
No, I was not.
Did you even know about it?
Not until after it was done.
And that was done at the aegis of the district attorney's office, correct?
Not relevant. No personal knowledge.
Sustain.
You weren't asked to help plan it, were you?
I was
Asked
not.
and answered.
Overruled.
Do you know why Andrea Mazzola was chosen to do that demo tape?
No personal knowledge.
Do you know anything about that?
No, I don't.
Were you aware of when it was being made?
No.
Did you see it after it was made?
Recently, yes.
When was the first time you saw it?
First time I saw it was after it was shown in this courtroom. Actually, I saw bits and pieces of it while it was being shown, but in its entirety after it was shown in the courtroom.
Did you notice in that video that when she collected a control stain, that the moisture from where she was collecting the control migrated into the blood stain itself?
Assumes facts not in evidence.
Overruled.
Yes, I did.
Is that an acceptable technique to collect blood evidence, in your view?
She wasn't collecting blood evidence at that point. She was collecting the control.
Is that an acceptable technique to use when you're collecting a control for a sample that you're then going to collect?
I don't see where it would affect your ultimate collection of that sample.
So that's acceptable to you?
It would be nice if they didn't come in contact, but I don't believe it is going to have any effect.
It would just be nice if they didn't do it that way.
Well, it's
Argumentative.
Overruled. You can answer the question.
Is it right or wrong, Mr. Matheson?
I don't believe it's wrong.
Okay. Did you notice the number of times she rubbed her hand on the ground when you saw that the first time?
Yes, I did.
Is that a good technique when you're collecting blood evidence to rub your hand on the ground?
Well, in that she wasn't then rubbing her hand on the evidence, I don't see where that makes a difference.
So that's okay.
Yes.
Did you hear her testimony where she said she wasn't even aware that she had done that?
No, I did not.
That misstates the evidence.
Overruled.
Did you notice the number of times in are doing those things? It's okay.
All right, everybody, that will be it for the night. We'll continue our trial coverage and reacting to other trials tomorrow. Thank you all for coming, and take care and peace.